Someone make it make sense.
Probably a couple.
Greetings, squirrel friends, for y'all that are hardcore when it comes to trials, like I suppose you want, or one might say I am. It's been a big week in the world of trials. It's been a big day in the world of trials, especially for those of you guys who have been following Delphi. You know, it was a long day full of closing arguments, and the thing that made it the hardest of all was we can't see any of it or hear any of it. It's awful. It's bad enough. It makes you nervous enough, even when you can watch it. But boy, I'll tell you what, in front of the anxiety or nervousness or even excitement or pins and needles normally that you might have during a trial when it comes to watching the closing arguments and like waiting for a verdict or whatever, there's not even a comparison when it's like you don't even know what's going on and you keep hearing it. It's just, anyway. So for those of you guys who are hardcore and just can't get enough, we are here to talk about the death penalty. So, you know, it is what it is. But here's the thing. We have, we've covered every single document court filing leading up to this hearing. I've been really looking forward to this hearing. I kind of hate that it happened at the same day as closing arguments in Delphi because it's just a lot. But nonetheless, it is what it is, and we are here, and I'm glad to be here. This is really important to me. I think it matters. Even if these motions don't go anywhere, which no expectation that they will, I do expect to hear, or I'm hoping to hear, some interesting conversations surrounding the trifurcated proceedings. And it'll be interesting to actually have another chance to see Judge Hippler in action, because so far we just had him at that one hearing, and it was very brief scheduling conference. He was super grumpy. Is he going to be, questions here that we might have. Is he going to be as grumpy today? More grumpy? Less grumpy? Like, what's going to happen with that? Looks like Santa's not there. What the heck is up with Santa? Another question. Where's Jay Logsden? He wrote the vast majority of these defense motions. So questions right off the bat. Will they finish in one day? Will we have any answers today? No spoilers in the chat. Those of you guys who have already watched this whole thing. I just saw the very beginning of it when it happened, which feels like a million years ago, but that was just this morning. So I don't know all the outcomes and whatever else yet, but we're going to discover together. So yes, without further ado, let's dive right on in. As always, guys, let me know if y'all have any questions.
All rise.
Or comments.
Is now in session.
Or concerns.
We see that.
Here he comes, Mr. Grumpy, Mr. Grouch, Mr. Grinch. Oh my God, sorry. Hold on. We didn't even get 2 seconds in. He's Mr. Grinch. Because if Prosecutor Santa is Prosecutor Santa also, hold on, let's do this. This is what we need. It's been a long day. It's been a long week. We have Prosecutor Santa, okay? Then that makes him, Judge Hippler, he's the Grinch. What do you guys think? I'll have to make a Grinch thing for him.
All right, we are back on the record in Ada County case CR 0124316665, State versus Kohberger. Counsel are present, I think with the exception of Mr. Logsden. Is that correct?
That's correct, Your Honor.
And counsel previously identified for the state are present as well. Is Mr. Thompson going to be on the?
Interesting. Previously identified. So that I was right off the bat wondering why is he not having them all identify themselves? So remember how there was talk about having a hearing outside of the presence of us regarding the Bryan Kohberger and wearing street clothes and what have you. I'm wondering if that's what happened, because it sounds like they just were having a hearing and then they went and had a 5-minute break or whatever and came back because just that way he said that. And that would make sense. And there's Bryan Kohberger in his street clothes, as it were. So that might be what happened here.
Okay. All right. So Mr. Thompson is appearing remotely. This is the time set for a number of hearings this morning. Yesterday afternoon, I issued an order by which the proceedings would be handled, the order in which that they would be handled, as well as designating the amount of time, generally speaking, that the parties or that the court will devote to the issue. The court has received extensive briefing by both parties and has reviewed it all thoroughly. So the first thing I want to address, just because the public was not here this morning, I did hear information from security and from Ada County Transport regarding security measures that would need to be taken had the court allowed Mr. Kohberger to appear in civilian clothes. The state did not object to Mr. Kohberger appearing with civilian clothes. The court has employed security measures and is comfortable in terms of the security and flight risk related to Mr. Kohberger with those measures.
Well, I think I was calling them street clothes. I mean, looking at what he's wearing, I think civilian clothes is probably the more appropriate term. But now I'm like, man, street clothes, like, that sounds like way cooler. Like, now I'm like, well, what would street clothes be? Like, I don't know. What would be, y'all, what would be a cool, what even are the street clothes anymore? I don't even know. Some fancy jeans, like maybe a baseball hat. I mean, you can't wear that in court. Like, what would be the fashion? What are the kids doing these days on the streets? That's the question.
And therefore has granted the defense motion to allow him to appear in civilian clothes. The first matter we have to take up.
I have to say, I like his tie, and I like his tie a lot more than this prosecutor's tie. Just saying.
This morning is the objection to the testimony of Dr.
Okay, so we talked about this. And I mentioned this on the last live stream for this case because I thought it was interesting. I was like, I kept saying I'm going to be on the lookout for a response as to these expert witnesses because I was like, well, they're scheduled to be at this hearing. Like, how can they not have a reply or a response as to like whether or not they're going to be allowed to testify? Because what are these supposed to tell their experts? And at the last live stream, which was, oh my God, they'll say yesterday. Yeah, yesterday. My God. Yesterday, I actually said, well, they didn't say anything. So like, I guess they're going to be allowed to come and testify. So I've been fully expecting to hear from both of these defense expert witnesses today. But it sounds like his plan was to just address it at the hearing, and which is insane to me that you wouldn't give them notice. But I guess we're going to find out now altogether.
Barbara Wolf related to the method of execution. So let's proceed with that. The state can be heard.
Your Honor, would you like me to address?
Please.
Yep. Thank you, Your Honor. Our objection on this witness is really just the ripeness issue. We think that this claim is quite clearly several decades early at this point in time, and that's assuming that there's a conviction and imposition of the death penalty. And so we're just trying to save everyone time and would ask that the court find this issue is not ripe before we have an evidentiary hearing on it. All right, that's the extent of the objection.
All right, thank you, Your Honor. Ms. Taylor.
Thank you, Your Honor. Your Honor, Dr. Wolf's proposed testimony is important for the court to hear and to think about the larger issue, and that is Idaho's inability to execute somebody at the given time. And there's a constitutional issue with having somebody sit on death row when there's no meaningful way for them to be executed. And Dr. Wolf's testimony will highlight for the court some information that may come up if Mr. Kohberger's ever convicted, and if there's a death penalty, and if he faces firing squad as one of the options.
Well, I'm not particularly convinced about your. Well,
so I have to say, Ann Taylor's looking flawless as usual. You know, and another thing. So the one time we've had the honor, requirement, maybe is the better word, of being around Judge Hippler. Actually, I'm working on in my head. Judge Grinchler, like Prosecutor Santa, Judge Grinchler. I don't know. I'm going to call him that for right now anyway. You know, we had the one hearing with him so far, and I mentioned how I couldn't put him in the thumbnail yet because literally I went through the whole thing, and every single clip, the entire thing, he's like completely washed out, and like it's not even usable. And I kept thinking, well, you know, usually with the way these court feeds go, right, is then at the next hearing, or if it's trial, like the next day of trial, or even just the next 10 minutes of trial, it can be completely different, right? It just fluctuates. And how funny is it that like they've got 3 cameras and like Ann Taylor's looking flawless in these two screens. Everyone else is looking high def. And then still somehow Judge Hippler is just completely washed out. And like, if I were to try to put him in the thumbnail, there would be no skin. It would just look like floating eyebrows and a mouth. And it would be very underwhelming, to say the least. Shout out to Flashman. Happy to see you. So hope maybe things will change, but let's see, maybe this will just be like the running theme of this entire, maybe this is how it is until trial finishes in November of 2025. Maybe from now on, we see Judge Grinchler and we get white with just a shade of some human features. And I don't know what I'm gonna do for the thumbnail. Maybe he just won't be in it. We'll see. We were just getting started. You didn't miss anything at all, except my my new nickname, because we've got Prosecutor Santa. This is the Cliff Notes version. All right, this is the important stuff, just the important stuff. Okay, so Prosecutor Santa is joining the hearing over Zoom right now, so he's not in the courtroom. So Prosecutor Santa, okay, and so because this new judge, Judge Hippler, I think I mentioned before, is grouchy and grumpy. I was just kind of nicknaming him. This just happened. Judge Grinchler. So then we have Prosecutor Santa and Judge Grinchler, but now I have to make a thing. I'll have to make an overlay and a thing for him so that he can be Judge Grinchler. I think he's got that vibe. He's got that Grinchy vibe. Yep. So, all right. Oh, nice. And so I talked a lot about Ann Taylor. For those of you who are kind of still getting familiar with this case, I've talked a lot about Ann Taylor because she is a gentlewoman and a scholar, to say the least. This is she, the legend. This is her face here. This is her again right here. And then this is the defendant. And then this is co-counsel. And then Mr. J. Logsden, who wrote most of those defense motions regarding the death penalty, is not here yet. He's coming in late. But right, so he's got 3 killer defense attorneys. The Ann Taylor being the lead, Elisa Massoth being co-counsel, and then Jay Logsden, again, who isn't here at the moment, but he tends to do a lot of the motions in terms of writing the motions. And then again, this is the defendant. So yeah.
Give that to you to the merits of it. Let's talk about whether we need to hear from Dr. Wolf first. So continue.
He does. He has.
I think that Dr. Wolf's testimony would provide the court with information about conscious pain and suffering, awareness of that pain and suffering, which matters.
Right now, they're fighting to get these expert witnesses we talked about last night, the expert witness testimony. They're fighting to get these allowed. So basically, it was kind of like planned that they were going to testify, and the state objected, and there was no ruling. So it was, I assumed, okay, they're going to testify because, like, why are we? There's no ruling, and now we're here. Like, we're here now. But they come on in and the judge is like, okay, now we're going to talk about this. And so now what's happening is this is Ms. Taylor responding to the state's objection to their expert witness testimony. And it's safe to assume these expert witnesses are in the courtroom or just outside the courtroom with the expectation that they'll be testifying. I shudder to think the cost that would be incurred should they show up, especially if there's travel time, and then not even be testifying. But we'll see what happens.
For the 8th Amendment, as well as why that information is known by her now. It's more recent information. It's after Idaho's history of having the firing squad and then removing it in light of the Bayes decision, and then in 2023, instituting it again. But this information about consciousness of pain and suffering happens in that window between 2009 and 2023. And I think the court should consider that and have that information. We also need to make a record in the event that there was ever a conviction in this case.
I wish I could zoom in.
Any rebuttal?
Like this dude, Judge Grinchler. It's like I'm watching. I'm like, is there any moment where he looks somewhat human where I could put him in the thumbnail? It's amazing. He's amazingly, surprisingly unphotogenic. It's kind of incredible.
Very briefly, Your Honor.
Okay, now the state's
I would just note that the defense did submit an affidavit. The court can review that. It clearly indicates what she would testify to if the court were to allow her to testify. So we don't really need to make a record because it already exists in the form of that affidavit. Thank you.
We saw
Thank you.
that.
All right. The court having reviewed the materials, believes that given the concerns about the current justiciability of the, or ripeness, if you will, of the issue, I do believe that the declaration is a sufficient proffer of what that general testimony would be that would allow us to discuss the issue. And so for the time being, I'm not going to hear from Ms. Wolf, or Dr. Wolf, I should say, her testimony. The declaration is an appropriate proffer. I will hear the merits of the motion based upon that proffer next. All right. So let's hear that from the defense.
Okay, so long story short, he's saying we're not going to hear from Dr. Wolf today. So I hope she didn't like come all this way and whatnot. I know it's you know, they're saying because it's not ripe. That's the word they use. And, you know, in other words, it's too soon to be making these decisions about what's cruel. You know, we talked about it, I think, a little bit last night. Was it last night? Yes. About this is what the state's saying for a lot of this death penalty stuff. Like, oh, it's too soon to be talking about it because if he's executed, it's not going to be for 30 years from now or whatever. You know, meanwhile, the state very well knows that the defense needs to go ahead and make any motions regarding the death penalty now. They can't wait 30 years from now. They're trying to spare him having to go through the death. They're trying to get this taken off. Like, they can't wait. And they know that, right? This has to be done before trial. It has to be done now. So the whole thing's silly. And I think it would have just been a little bit more polite to at least, if you're going to just flat out deny it, at least say it before the hearing, because Dr. Barbara Wolf has come all this way. You know, and you know, the really crappy thing is, you know, the defense has limited resources and they're paying those experts for their travel time as they should, but it's just a shame and a waste. And I would have liked to hear from her. Now we will hear from her at some point, it sounds like, but so what they're saying is she can't testify, but they're going to be allowed to still make their argument based on the proffer of what she would have testified to. Like, I can just picture her like outside the doors there at the courthouse, like, I'm here. You know, but it's like, no, they have to just say, here's what she would have said, when it's like, well, I'm here, I can say it, you know. I don't know. Well, yeah, I'm not a huge fan of this judge at all. Like, I think I said, like, I misjudge judge. But you know, we will I try to think to myself, could he be as bad as Judge Bev? Could he be as bad as Judge Gull? No, right? I mean, it's hopefully not. I hope not. We don't need another one of them. So, anyway, so they're still going to argue this motion here. So let me put up a banner.
Thank you, Your Honor. I would ask the court for leave to supplement that declaration. The information that is more recent between 2010 studies and a book that was published that is relied upon by Dr. Wolf, that's not contained in the declaration. And I would like to make that part of the record too from her. So if the court continues to have her testimony not be allowed, I would ask that I be allowed after the fact to make that part of the record.
You can submit that, and I will then hear any objections to that, and I will consider that.
Okay. Thank you, Your Honor. Then moving on to our argument, and I will largely not repeat what's in our brief since the court has had a chance to take a look at that. We think that the court ought to strike the death penalty in this case and not allow the case to go forward as a death penalty case because Idaho does not have a current means of executing anybody.
All right. So they're starting right off with the one we actually went over last night. So because there's a whole lot of motions. There's like, I don't know, I think maybe over a dozen motions to strike the death penalty. And then there's also motions to strike each of the 4 statutory aggravators. And then there might be a handful of additional ones that aren't covered in those 2 broad categories. But so they're starting off first with the one we just went over last night. So the motion to strike the death penalty on grounds of means of execution. So we're well familiar with that. So I'm going to put up a banner, but we'll let her keep going.
When somebody sits on death row and there's no real means of executing them, that is dehumanizing to that person. That's similar.
Say there's no means under Idaho law, the
Interrupts her already.
method of execution is lethal injection, and if unavailable, then the firing squad. You rely significantly on the idea that lethal injection is not available based upon the quote unquote botched execution of Mr. Creech.
Don't call it quote unquote. It
It
was
seems to
botched.
me that was a particularized
boy.
incident wherein Mr. Creech,
Oh,
the execution really hadn't even begun yet in the sense that they couldn't locate a vein. I don't see how that issue is universal.
Your Honor, I would agree that Mr. Creech's, the situation that happened to him was unique to him. I don't think he's the only person that has ever had that happen. I'm not in the state of Idaho, but I think that that's happened before when the means of execution couldn't
It
be employed at
has.
the time.
It has.
But since we're talking about Idaho, I think we should look at what happened in the Pizzuto case too. And in that case, there was no ability to obtain the chemicals to kill him with. And so his execution, his death warrant expired without him being executed. After that happened, Idaho passed legislation that would allow the Department of Corrections to obtain the chemicals to kill somebody in secrecy. After that happened, there's still a lot of difficulty getting the chemicals because pharmaceutical companies don't like to have
They
their,
have obtained them twice now, since then.
they've obtained them twice for Creech, yes. Now, something has changed in the death chamber for how they will try to execute Creech. I don't know what that is. That's probably one of those things that we'll learn a little bit more about through Creech's.
Well, I think that they're going to utilize a central venous catheter. In other words, accessing a central vein rather than a peripheral vein. My understanding that there's federal law approving that procedure, as well as a recent decision by the district court approving that procedure. I think that's the difference.
And I think, looking
Yeah.
forward, we just don't have those answers yet. We don't know how that's going to unfold. I don't believe his execution is moving forward as is scheduled. And if we look at the immediate history in Idaho, and that's what I'm looking at. when
Now
I'm standing
let's, I'm saying this for both our sakes, Flash fan. I agree he sounds irritated. I've been saying he's grumpy, he's grouchy. I'm saying this for both our sakes. Let's just hope he could be grouchy. He could be grumpy. He could be crass or cold, or he could be anything, right? I don't really think we have, at least in my opinion, enough information to say that he's biased yet, because literally we've only seen him in action for not that long. They had one brief hearing a few weeks ago. It was 20 minutes or less. And we're only just at the beginning of this hearing. So I don't think I can say for sure, that I can't, I think the jury's still out on that. No pun intended. It would take time to establish a clear bias, I think. So let's try to see if we can stay positive and he could be irritating, he could be grumpy, grouchy, he could be whatever. But, fingers crossed. Hopefully, if nothing else, at least he is fair. We'll hope for that.
before you representing Mr. Kohberger and saying to you that Idaho doesn't have a real means of executing someone. The firing squad ended up on the books because of the difficulty obtaining the drugs to kill somebody. That's why the firing squad came back. The history of the firing squad, which is really well written by Mr. Logsden in our briefing, is that it sat on Idaho's books for years. And in 2009, it came off in light of the Bays decision. When you think about it coming off in light of the Bays decision, and you look at what's happened since the Bays decision, we're going to talk about that a little bit later today when we're talking about evolving standards of decency. We'll talk about how things have changed in this country since then. But for these purposes, when you look at that and you realize Idaho brings it back in 2023, they bring it back because it's not reliable to believe they're always going to be able to get the chemicals to execute somebody. And that's the real problem here. The firing squad hasn't been funded well enough to be built.
I think they're building it right now, as I recall, from the media at least, that the construction is actually underway, but I may be wrong about that.
Well, I haven't talked to the director of the Department of Corrections, and that's probably who I would take my word from if that's actually happening right now.
Wow. What the epitome of grace and eloquence. He's saying, well, they're building the whatever infrastructure they need to have the firing. So he says, well, they're building it right now. And then he says, that's what I got from the media anyway. How eloquently did she just handle that by saying, well, I haven't heard that from the Department of Corrections yet, and that's who I would want to make sure I hear it from. Well done, because you know what? She wouldn't have been, she would not have been completely out of line. Well, it would have been understandable to have pointed out that the media is not maybe where you should be getting this information from as a judge, right? As a judge, maybe you should be getting it right from the source. But anyway, I just thought she handled that with eloquence.
I think there's some additional problems with the firing squad, though. I think there's some problems with the way our statute lays it out too. If you read our statute, and the court just summarized it, it's lethal injection unless it's not available, and then it's going to be the firing squad. But the way that's written is that it's firing squad unless the director of the Department of Corrections says, I have the chemicals and we can do lethal injection. And I think there's 5 days that exist for the director of the Department of Corrections to say, no, we have the drugs, we can do lethal injection now. That is problematic. There's not a choice or an election, and other states have an election for the condemned person to choose from, but Idaho's not allowing that. Additionally, the information that I think is really important to the court is to understand things and advances that have happened in understanding conscious pain and suffering. If Dr. Wolf had been allowed to testify, she would tell you that she relies on studies from 2010, a working group from 2010, and a book that was published later than that even, and that's post the Bayes decision. And that talks about understanding what a person is conscious and aware of when they face the firing squad. That's information that's important for the court when considering whether or not to strike the death penalty, because Idaho's means of execution really doesn't exist. Thank you.
Can I ask you, even if your motion were right, and even accepting as true that the current means of execution are either unavailable or would violate the 8th Amendment as cruel and unusual, how do you get around Buckwell? You've not provided a alternate means of execution.
Well,
and I know, and I understand from your perspective, it's not something defense counsel wants to do, is to say, no, do it this way. Execute my client this way. But Buckwell provides that if you're going to challenge the means of execution, you have to, as a condition proceeding, provide a available or an alternate, I should say, means of execution.
I would say, to your honor, that we're not at the place where we would have to make that decision yet.
That speak to the justiciability of the issue overall.
I don't think it does. And I think that the separation and the difference is that we are in a place where we're preparing this case to go to trial. We represent Mr. Kohberger, who sits there, an innocent man right now, but we're preparing this case as a capital case with all of the things that involves, all of the requirements that are upon counsel that take a lot of time, a lot of work, and a lot of money to do this. And so I think when we're looking at the constitutionality of the execution, I think that's different than if there was a conviction, and if there was a death sentence, and if the post-conviction proceeding and the appeals were unsuccessful for Mr. Kohberger.
Doesn't that speak to your motion in the sense that you're saying take the death penalty off the table, don't let the state put on that evidence because the current methods, in your view, are either unavailable or unconstitutional. But the reality is if he is convicted, we know it's going to be a decade plus before that sentence would be carried out. And who knows what the methods may be then. And, I think that's part of why you're saying you shouldn't have to comply with Buckwell. But it seems to me that same rationale then applies to why I should even consider this motion. Why wouldn't we wait until that time frame to see what the current methods are?
Something, oh, guys, I'm here. Don't panic. I just thought something kind of funny. Like he said Buckwell. I was like, if you reverse it, you get, well, Buck. Anyway, that's what's not funny. I was going to say also that another judge that I like, and I'm forgetting his name because I guess I haven't really seen him in a while. The judge from Corey Richens. I like that judge as well. And I also liked Judge Summers for Baldwin and Hannah Gutierrez Reed. I liked her a lot as well. I liked her a lot. She really, the way she, that's a redeeming, let's just remind ourselves, that was a redeeming moment that was really necessary because that happened in the thick of it with the Karen Reed trial when that whole, the case was dismissed due to the fuckery with the prosecution with Carrie Morrissey. And the way Judge Summers laid down the law and was like, dude, it was moving. It was moving. I was like, this is it. It was like, it's like they got the information, turn around an hour. All right, done. There's no question. This is not how we do things here, And it was like, yes, that was so honestly, I almost feel like we could make a little clip of some of those moments that day and just put a little feel good video together for when all the other judges are being stupid or biased and, getting us down. It's like, we can watch we can have a little pick me up. We could have some clips of Judge A Like we could have like a little best judges, like Judge A and like Judge Newman and the Judge Saunders and all of our other favorite judges, like in some of their great moments, being great servants of the judicial system and making great decisions and justice and and it's like I don't know, I'm just so yeah, I've not heard anyone say he's biased, the Corey Richards judge. Again, I don't remember his name. I've not heard that from anybody, but it's not like I'm not on, so I don't know if people hear things. I'm not on social media, so if that's where things are heard, I'm not in that loop. But from my experience watching him and from just my exposure, he seems to be really fair and balanced. And also, I believe he also wears really cool ties. Also, a plus,
Technologically is going to be available at that time.
I definitely hear what the court's saying. I would come back to saying that we're not in the place where he's challenging the methods that's about to be employed. We are decades away from that, if that were to even happen. But what I'm saying is, I don't believe that our Constitution allows for us to move forward and make him sit on death row for years and years and years, when the way Idaho's doing it right now isn't really working. It's not a realistic option. I think to have him sit on death row and say, Idaho's going to figure out how to kill you at some point in the future in a way that isn't cruel and unusual and in violation of your rights, I just don't think that the constitutional protections allow that to happen. I think that.
So you're saying the anxiety of not knowing is the constitutional violation?
I say that, and I believe that the Troop versus Doles was cited in the brief, and the comparison there is what I'm saying the Constitution doesn't allow. It is anxiety. It is fear. It is the not knowing.
I mean, to be fair, the Idaho Supreme Court just ruled that anxiety and fear in the Grinch case was not sufficient to preclude his execution just this week.
I read that opinion, and I read that, I guess, more particular to the botched execution attempt versus sitting there for decades and not knowing how and if it would happen.
No, but it was anxiety that was the
saying.
underpinning.
I see what she's saying. So that botched execution, I think we're all aware. It was in the thing we read last night. The motion, the botched execution. So with part of what was, and there's a lot of problems there, but part of the issue with that, right, is like, they tried for like some crazy long period of time, and like 8 different times they tried to kill this dude. It didn't work. So part of what made that such an atrocity was that he's sitting there like waiting for them to successfully kill him, and they keep failing, and then they keep trying over and over again. And there's like the anticipation, the anxiety of not knowing when it's going to happen. So what she's saying is actually a really creative argument in terms of using that as an example where it could fit here, that she's basically kind of saying, well, it's basically the same. Like if you're young, and you're convicted and it's a death penalty case and you're put on death row, and the state does not know how they're going to kill you because they don't have an actual valid method, then it's the same thing. But instead of like having to wait around in anxious anticipation for an hour or 2 hours or a day, you're having to do it for decades. That's what she's saying. So she's saying it's like the same thing, but more time. That's the argument she's making. It's a creative argument. I mean, I don't think it's going to go anywhere with him, but I think it's creative given that, again, these are some of these motions are really just more for the record than anything else. They're not really expected to go anywhere. So you've got to give them credit when they come up with a new angle to it, right? When it's like, these have been heard a bazillion times, these same exact motions, right? This is standard practice, right? Part of providing effective assistance of counsel. So when you come up with a new spin on it, props to you for that.
And I don't mean to disrespect what Mr. Creech felt or went through, but you're talking about realistically from February 29th, if this was leap year, until now, and what you're talking about for Mr. Kohberger and what would happen if he were convicted and if he were sentenced to death. would be decades. The court just acknowledged that it's decades to sit.
Well, I said
And no
a decade,
disrespect to the anxiety Mr. Creech felt. I think that must have been horrible for him. But to sit for decades and wonder is a lot longer. And so I understand what the Supreme Court said. I did read that too. But I think it's different when you're just starting out here in this circumstance.
Thank you. Aye.
Thank you, Your Honor. I'll try and keep this brief. I don't want to repeat much what's in my brief, and I think a lot has already been discussed today, but I want to start by pointing out, one of the things that Ms. Taylor just said was, looking forward, we don't have the answers to that yet. Well, that's the whole point, is this just isn't right. We don't know what's going to be available decades from now, and it probably will be decades, plural. If you look at, Idaho's track record, Mr. Creech, Mr. Pizzuto, they were convicted back in the 80s.
Take as true, for the purposes of my question, that the state doesn't have a method. Should defendants be tried for and potentially sentenced to death when the state has no method of execution currently?
Yes, Your Honor, I don't see a problem with that, because deciding the method of execution is not deciding the
don't know if
sentence.
the
The sentence is death. The method of execution is just how that's brought about. And so even the United States Supreme Court has recognized that someone who was convicted and sentenced to death, in that case, I believe it was hanging, and then after he was sentenced to death, the state passed a law, made it electrocution, and the US Supreme Court said there's no ex post facto problem with that, because you're not changing the penalty. The penalty is death. And so even if you assume that Idaho cannot do lethal injection, and even if you assume that the firing squad is unconstitutional, that's not to say that decades from now, there is not going to be a method by which the state could put him to death. And then, of course, I was accepting the hypothetical as proposed, but we would strongly push back on this idea that Idaho doesn't have a method of execution. There was a scheduled execution to take place on November 13th, just days from now, that was only stopped because the federal district court entered a stay so that it had time to consider some additional claims. But in that case, Director T-Walt put in an affidavit that said, we have the chemicals, we can do this. We've modified the procedure to address the individualized problem that came up with Mr. Creech before, and so we can execute Mr. Creech. So there really is just no evidence whatsoever to suggest that Idaho can't do this, and certainly not that it can't do this decades from now. And again, that gets back to the rightness issue: is it may be lethal injection, it may not, it may be some other method, but we just don't know enough now, frankly, to spend the time and the effort debating what we don't know in the future. That's the entire reason the rightness doctrine exists. I also want to speak just briefly on the Bucklew point that the court brought up. What I'm hearing from the defense is they just have this kind of like vague Eighth Amendment assertion of maybe it's kind of the anxiety, but kind of not knowing how you're going to be executed. Well, that's not how the law works. There's an established framework of how you can make an Eighth Amendment method of execution claim. And Bucklew, the court specifically said, I'm quoting here, identifying an available alternative is a requirement of all, and all is emphasized in the decision, all Eighth Amendment methods of execution claims. You can't get around that by just saying, well, but I'm making a slightly different kind of claim. It's not a method of execution claim, it's a means of execution claim. That just doesn't work. That's not how the law operates. And so they haven't even suggested, even today, an argument what a proper alternative would be, which also gets back to the rightness issue, which is we don't know decades from now what an alternative might be. Maybe they'll have a better argument decades from now on the method of execution, because maybe there will be a better method. And that gets to the final point I want to bring up, which is the remedy here. They're asking that the death penalty be struck because these methods are unconstitutional, but that's not how it works. If you show that one method is unconstitutional, part of the reason you have to present a viable, readily implemented alternative is so that the state can then use that method for the execution. You don't get to, at the beginning, short circuit the whole thing and say death is off the table because the current method is unconstitutional. As I said before, the method could change. And so if they came in and they had evidence and they could show that there was another method that's not lethal injection, that's not firing squad, that severely or significantly reduces the pain, and it's readily implemented, the answer isn't to strike it, the death penalty completely. It's to say, okay, you can move forward with the trial. We can see if he's sentenced to death, but you can't use those two methods to do it. If the state wants to pass a law and do this other method that he's proposed, then you can do it that way. So for all those reasons, Your Honor, unless there's any further questions, we'd ask that the court deny the motion.
Thank you. Any rebuttal?
Just briefly, Your Honor. The distinction is not us being on death row with a death warrant that we're talking about. That's a different kind of conversation. We're well before looking at the overall picture and saying the Constitution protects somebody from sitting in prison when there's not a real means to execute.
Do you
I
have
understand.
any case that says that?
making an analogy with the troop versus doles and the denaturalization with the dehumanization that happens if somebody sits on death row when there's not a realistic way to execute. I understand that lethal injection has not been overruled. I understand that. But when we're talking about the recent history of what's happened in Idaho, there are problems, and there are real problems. We talked about Pizzuto, we talked about Creech, we talked about 2 pieces of legislation to try to make this work, and it just doesn't work. So we're in a position where I'm not with a client that has a death warrant, and we're talking about whatever they'll probably talk about with Creech, with how they're going to do injection. We're not talking about the marksman involved in a firing squad. We're talking about way back here when we're sitting with constitutional protections, and Idaho's got all these problems with executing somebody. And how is that right, fair, any protection under the Constitution for somebody to have to sit there and just wait for Idaho to figure it out? That's the difference in our argument.
Mhm.
That's it. Thank you.
Thank you.
All righty. I think they're going to be on to the next one.
All right, court will take that issue under advisement and issue a written opinion with respect to
Okay.
its ruling.
Well, that
Next, I
is
wanted to
a
take
good
up
indication. So this has been the first motion in terms of for today so far. And the fact that he said he's going to take it under advisement, I think that's going to give us a good indication that he's not going to actually like rule from the bench today, that he will be submitting his, his decisions in writing. Again, I think probably going to be denied, but not that was just one thing that was like, well, is he going to actually say something today, or is he going to offer it in writing? But the fact that he said that here, I would expect that then to be par for the course going forward.
Objection
That's
to
why I had a
Professor
British
Kohberger's
accent.
testimony.
Your Honor, as the state pointed out in its written objection, Professor Cover's testimony is
Is it
largely,
Cover or Kohberger?
I believe, I'll defer to defense counsel. Is it? It's Cover.
Cover, thank you.
Thank you, counsel.
Okay, so I'm forgetting this prosecutor's name, but she was also prosecutor. I think she was what was she? Like second chair for the state when it came to Daybell. So someone you might remember, someone in the chat might remember her name. I'm blanking on it right now. But right now they've hopped back over to the topic of the expert witness testimony. And so now they're back to discussing the other defense expert, who again is probably waiting in the wings, Dr. Cover. And again, the reason that we're hearing from the state first, let me change my banner, is because they're the ones objecting to her testimony. Again, she's probably here on location. And so they are going to be heard first because it's their objection. I love her, what is that, a sweater, a cardigan, a suit coat, whatever that is she's wearing. I love it.
Professor Cover's testimony in this case would largely center around a legal analysis that she conducted over several other murder cases throughout Idaho. Now, the first reason that this isn't appropriate is because legal conclusions are just not the appropriate subject of expert testimony. The state cited to Ybarra in its objection, and in Ybarra, the Idaho Supreme Court held that legal conclusions by an expert were not proper for consideration before the court. Now, that expert was allowed to testify as to factual.
Literally, Miss Beatty, if you ever watch this live stream, can you please tell me where you got your outerwear, your overcoat, I don't even know what type of garment that is, but whatever, I absolutely love it. And I just would like to have one just like that. So, not to be creepy.
Conclusions, but the court struck legal conclusions from that expert's declaration. Additionally, as the state also pointed out in its written objection, the Idaho Supreme Court straight up rejected a similar attempt to do an analysis over first-degree murder cases in an attempt to argue that Idaho's statutory scheme doesn't accomplish narrowing. And so I think the court can look to the Hairston case where it was an almost identical argument, and the court found that it simply wasn't relevant, and also preclude Professor Cover from testifying on that basis as well. When the state received the PowerPoint that Professor Cover would be utilizing, many of these slides are simply excerpts from statutes.
This PowerPoint itself is titled An Empirical and Constitutional Analysis, and that's largely what her statutory scheme just doesn't accomplish narrowing. This is a legal argument, and the state would ask the court to preclude her from testifying on that basis. Thank you, Your Honor.
Massoth?
Good morning, Your Honor. The first argument that I'd like to address relates to Hidalgo. And in the Hidalgo case, the state of Arizona had actually conceded that there were statutory problems. And when the Supreme Court took that into consideration, the reason that they did not issue a cert was that they wanted a robust discussion about gathered data, analysis, and have that come under the scrutiny of cross-examination. And so that's my first point to you today, is that the United States Supreme Court wants what we're wanting to accomplish here today with Professor Cover. They want that discussion to occur so that the data is and studies are scrutinized and discussed, and a trial court like you has the ability to make a full assessment. Reading a paper doesn't allow you to do that the way that the expert who did the study can explain it. The other point that I want to make is that as it relates to the Hairston case, I pulled the underlying briefing in that. So the underlying briefing in Hairston was a direct appeal and a post-conviction appeal, and they were consolidated. And the study that Dr. Jensen did was nowhere even close to what the study that Dr. Cover did.
But the court's thrust was that the legal analysis is not whether the statutory aggregators cumulatively narrow the class of first-degree murders eligible for the death penalty, that's not a relevant legal analysis. The legal analysis is whether an individual aggravator does so, that it excludes rationally first-degree from among first-degree murders within that particular aggravator. And as I understand Hairston, it's just not a relevant issue. It's not a legally,
So
it's not an
I'm
issue.
just ahead a little bit because I think it sounds like he's not letting these experts come in. So let's just go ahead a little bit to get to the next motion.
Framed as,
Feel bad for the experts.
did Idaho's method of compelling return
Different.
eligibility and looking at eligibility of the death.
Again, this is still dealing with what Dr. Cover, we'll hear from these experts at some other point, just not going to be today. So I'm going to just go ahead here. They're making their record. He's not going to let them testify. I feel bad for them having come all this way. Judge, what was it called? Judge Grinchler.
What
Into
our court said in here. Listen to traders fronted when we want this court should hear that so that you can make a reason.
Okay, I'm just going to pause it and fast forward so it's maybe less annoying. She's back up.
The Nuxall case,
So this is for she's back for rebuttal argument. So they're still going on this one regarding Dr. Cover, Dr. Carpet, Dr. Rugg. Just thinking of other similar things. Okay.
Indulge you.
Judge, we will be able to get through in one day. I think that the argument that the state just made feeds my point, which is they're drawing conclusions off of the raw data without talking to the expert. You know, when an expert provides.
So I think what happened there was he must have been giving them a hard time for still wanting to argue further on this issue when they have a lot to get through. And so that's why she said, I think we'll get through in one day. But having said that, she's now rebutting the rebuttal argument. So we're going to skip past that to get past to the next death penalty motion. All right.
Algo is
She's not done yet. Going strong. All right.
proffered testimony of Dr. Cover will be relevant or helpful to the court to decide
Cover,
this issue.
Dr. Cover.
I think that I can rely upon her law review article and the data that is committed to this court's disregard by experts. The court is the
Okay.
narrowing requirements from the court. Individual of the Idaho Supreme Court through her Cover back at a later date to provide that information. I'm not going to preclude the argument on the merit now, and so I will hear argument on
All right,
the
here we
merits of the motion to strike the aggravators writ whole.
This is not the argument on the individual aggravators,
Okay.
but on the collective aggravators.
Collective aggravators. Sweet. Let's do this thing. I love this. This is one of my favorite parts. Okay. That sounds weird, right? 'Cause the thing that I'm most looking forward to is hearing the argument when it comes to the aggravators, because the motions to strike the death penalty as a whole, again, these are kind of like your run-of-the-mill boilerplate standard, motions that are made for every death penalty case to preserve the record, dealing with your constitutional rights, stuff like that. Not really usually expected to go very far. But the aggravators, though, that's where it gets different, because those are going to be varied depending on the state and the facts of the case. So as we learned, there were 5 initially, and just I think 2 weeks ago, the state actually dropped one of the 5, and now there's only 4 left. So this is where it gets a little bit more interesting, and there's more room for potential, I think. So right now we're going to hear argument on motion to strike the aggravators as a whole, like as a collective. And then later we'll hear each as individuals. But he used I'm going to back it up so I could hear what he called it exactly. Writ whole? I don't know. Funny.
The merits of the motion to strike the aggravators writ whole.
This is not the argument on the individual aggravators, but on the collective aggravators.
We are asking the court to strike the death penalty because in Idaho, there is no narrowing of eligibility, which results in arbitrary imposition of a death sentence. We are also asking the court to strike the death penalty as a violation of the Equal Protection Clause. I will argue narrowing first. When it comes to the determination of eligibility, it begins with the definition of first-degree murder. And when the definition of first-degree murder is looked at, then the next thing that happens is looking at statutory aggravators. And the reason that those two things exist in Idaho and those steps in analysis exist in the United States is because of the Furman case. It's important to distinguish between eligibility to be charged and selection, which is at a post-conviction phase of a case. And so our argument and our focus for this issue is on the eligibility phase. What
Your argument doesn't consider the weighing of mitigators against the aggravators is what you're saying, and the appellate review available. You're simply focusing on whether collectively the statutory aggravators narrow the class.
Let me answer the mitigation question first. Mitigation
Like objection compound.
is in the selection
Right.
phase.
That's what I'm saying.
So I'm not arguing about that. I'm going to step and grab my water.
Sure.
Oh boy.
I want to be clear about the argument and eligibility that I'm talking about the definition of first-degree murder and the aggravator statute, because our definition is so broad that there
It is
is
broad.
no narrowing.
It is
there.
broad. It's very broad.
And
Sorry.
so that is an important first step
Yes,
that the prosecutor in their discretion, they're looking at, and there's essentially no guidance with the
Yeah.
first degree definition. And so you do get to the narrowing factors, which is the duty of the legislature that cannot be
Yes.
abrogated to any other branch to fix
Right.
when there is no proper narrowing. Professor Cover,
just to refresh y'all's memory, what they're talking about is the narrowing is so super important when it comes to the death penalty. So basically, I'm not going to pull up the documents again, but again, for anyone who's interested, everything's always time stamped, but it's really fascinating when they talk about the way this narrowing works, because it's this idea that why do we have the death penalty? Why do we have it? What is it's the ultimate punishment, ultimate capital punishment, right? Obviously it's like we said last night, there's plenty of states that have capital punishment, but the capital punishment is LWOP and not death penalty, because so few states even use the death penalty anymore. But so it's being that it's the worst punishment. Well, okay, I guess it would stand to reason. The point of it is that it's designed or intended to be given to the worst of the worst. And if that sounds like, well, that can't be like an actual definition, that's actually one of the examples given in the motions as to how it's been used or referenced, I think, in other case law, actually, the worst of the worst. Sad, right? That's what they're dealing with. Vague and subjective, just for starters there. So, so the narrowing thing is really important, though, because that's the whole point, right? If you've got a group of 50,000 murderers that all were convicted of first-degree murder, how do you determine how many, if any, are worse than any others? And if so, how? If so, how? That's the big question. If so, how? And the problem then, after that question is asked, is that all of the answers so far in the documents that have come forth on this are equally vague and subjective. It's it's so arbitrary, it'll make you want to pull your hair out. There's no, and this, we're getting into the heart of why I feel this is so important, because there's so many issues with, legally speaking, there's so many issues with this type of punishment that honestly doesn't really exist with the other types of punishment. It's very specific to this. And you'll run into these other concerns when it comes to the other possible sentences. So it's like this, it's in this own category where it's like no one can quite define evil in a way that really sets it apart in an objective manner. Or the one that I hate so much, the heinous, atrocious, and cruel, evil. I hate that type of shit. I find it appalling. We'll get to that when they get to the HAC aggravator more, but all that stupid stuff. It's like, and then in one of the documents we were reading, it's like they're like, how do we set it apart? What's the narrowing? It's like shockingly vile. It's like, okay. I mean, so another one was just to give another example, was like if they used it, what was it, like if it would offend the common moral decency, like, give me a break, man. That is going to be different for every person you ask. It's not even worth getting into. It's that stupid. So anyway, so that's what we're dealing with, guys, when they decide who's going to die. Among other things, that's just a few of the little, that's just a 50 trillion foot overview of some of the issues here. Yeah. And I'm very ashamed that North Carolina has it, although thankfully North Carolina has not used it in quite a long time. I don't remember when the last one was, but it's been a while. So I'm thankful for that. I wish we still didn't have it. But yeah, so, and yeah, definitely second that. Flash fan on that, Lori. But so yeah, so the narrowing is a big deal because here's the thing, guys. The rules say that the state can only charge someone with the death penalty, or not charge someone. They can only intend to seek the death penalty, rather, or seek the death penalty, right? If they have shown that they have sufficiently narrowed the pool. So when I say the pool, right, when you hear these phrases, narrowing the pool or just the pool, right? Remember we talked about that initial 50 group of the 50,000 people who committed first-degree murder, hypothetically, right? Just, imaginary, that 50,000 pool group, that's your pool. How do you narrow that 50,000 into who's worse than the other guy? And how do you decide who's going to get the death penalty and who's not? That's the narrowing the pool. And it's required of the state to be able to do that, legally speaking, in order to then seek the death penalty. So then what you find is in the case law and in all this, so we covered it, whenever they're like, yeah, here, look, we're narrowing. And they're like, here's how we're narrowing. And then they give an example and it's like, and it's like just one of those silly arbitrary things. And it's like, and then someone's like, yep, check, you narrowed. And anyway, I'm sure we'll hear more about it. But just so you guys have an idea, the narrowing is really important because if they can't narrow the class, it's a no-go. But the problem is the problem that has been happening from what I've seen here, like historically speaking, not related to this case, just over time, is that whenever some prosecutor gives some stupid BS nonsensical example of here's how we're narrowing, then somebody signs off on it. Yep, that's good enough for me. And then it passes, right? And so anyway, all right. I mean, really, you know, we always hear this, right? These trial court judges, they don't want to be the one to upset the apple cart. I think that's the saying, topple the apple cart, ride in the apple cart. What, steal the apple cart? What does one do to the apple cart? Anyway, they don't want to be that judge. And so they all, so that's what it looks like. And so these are always before the trial courts, and then they're like, yep, good enough, right? And then move it right along, and then that's it. Status quo, status quo, status quo.
Concluded that when you analyze those things with the 195 cases that she reviewed and collected data on against the number of death verdicts, which is so low, that you end up with a statistic that is worse than the statistic that the Supreme Court struck down in Furman.
Well,
And
so the Furman's an interesting decision, right? Because while I recognize two of the justices talked about those specific statistics, I don't know that those specific statistics are in fact a binding opinion of the court. There's much more in Furman apart from the statistics that two justices relied on.
And I don't disagree with that, but it's certainly guidance for the court. You know, when you're not hearing testimony from the expert to explain everything that was
Good for
taken
her.
into consideration in the conclusions that she drew, then
Good for her. Way to bring back in the fact that she's like, well, Your Honor, part of the problem is we can't help you out here because we wanted to bring in Dr. Cover and you're not going to let her testify today. So,
what I'm going to do is take it at the high level that Furman is the guidance of those statistics. Her statistics show that
I'm
Idaho's
sorry, that's
were
terrible.
vastly
I'm
worse.
so sorry you're allergic. And I'm sorry that my apple cart confusion ended up making you want apples. DC doesn't. Yeah, I've never even. Okay, so maybe that's why I've never heard of a trial there. Yeah, I have no idea. I don't know. I'm gonna look it up though. This is a great point. Flashman was saying how trials work in DC because they're not a state. It's like throwing my brain for a loop there because it's like, what category is that? Like, how does that? I don't know. I'll have to look it up.
Worse. And so it's certainly something that the court needs to take into consideration in terms of whether or not there is the ability to narrow in the state of Idaho. The conclusion from the expert who did the study here is that there is no narrowing.
And my question was more a legal one, which is the analysis by Dr. Kohberger in her extensive law review article takes as its starting point that you have to have a statistic below that identified by the two justices in Furman.
Your Honor, I guess I disagree that that's where she draws a hard line there. I think that it's guidance.
Okay.
And there were other states that she looked at that she could certainly, if she testified, explain what was going on in all of the things that were going on in her analysis. But I don't know that my interpretation is that there's this hard and fast line, but certainly we have a line that the United States Supreme Court looked at, and Idaho's is worse.
Okay, who's up next? Who's going to argue for the state? I wish I knew that dude's name.
So the problem when you have no narrowing is that instead of it being a situation where the worst of the worst are being charged with the death.
There it is, guys. I called it. Remember a second ago when I said the worst of the worst? There's that languaging. There it is, worst of the worst. That's literally been the narrowing. That's the way that the narrowing has been discussed in the past. The worst of the worst. It's incredible, really, when you think about it. Oh, spinny wheel. Come on now.
Penalty.
Okay.
Everyone falls within that category.
Right.
And that cannot be remedied by anyone else other than the legislature, because that is their duty. And if there's no narrowing, then and it's arbitrary, then that's a basis for this court to strike the death penalty. There were, when Dr. Cover did her study, she looked at other states that
Judge Grinchler is wearing jeans, y'all. Well, I mean, that's what it looks like.
did a better job of narrowing in statutory aggravating factors. And I want to give the court an example of what that looks like. In the state of Oregon, which actually is on pause with its death penalty right now, a narrowed statute there is the murder of 2 or more people or terrorism while in custody and after a previous homicide conviction, premeditation and against a child under 14 years of age, or premeditation and against a police officer or an other officer. So that
Those are examples, and that makes sense. Those are examples of objectively narrowing the pool. Those are great examples. Those are great examples. So she's saying, even though right now Oregon is not using the death penalty, if they were, these are the examples of how they narrow it. These are their objective factors, right? Here's how, like, so common sense, right? You know, whereas in Idaho, it's, you know, disregard for human life and heinous, atrocious, and cruel. Shit like that, which is, you know, anyway, all right.
that's an example of how a legislature can certainly make an attempt at getting factors much more narrowed and tailored. Now, Oregon's hasn't been, as I understand it, has not been taken up on appeal, so it hasn't been analyzed at this level, and the death penalty is on pause there. But it is an example of a statute that can be narrowed. The other thing that I wanted to point out is that the state of California versus Tulipa, and I hope I'm saying that name right, has a statute for aggravators that in and of itself carries a whole bunch of mitigating factors for the state to actually take into consideration. So the state doesn't wait until it's very clear that the state is looking at what only happens in Idaho at the selection phase and not the eligibility phase. The other point that I want to make about our motion on this is the issue of geography. And I want to point out that we are arguing geography in the context of equal protection, which is a unique argument that has been made in Idaho and has not been addressed on appeal when it was being raised in Harrison over financial resources. And the point was geography. It was in the context of arbitrary and capricious and not in the context of equal
But as I
protection.
understand your analysis is that the there's a predilection for capital cases to come from geographic centers of large populations, correct?
Correct.
Client's case does not stem from one of those.
That's true, Judge, but this is not, we're not talking about the facts of our client's case right now. We are talking about Idaho's
Your claim
statutory
is a,
scheme.
On the whole, your claim is that it violates equal protection.
Correct. And not only on an Idaho level, but also on a national level, when you take into consideration how many states have stopped using the death penalty or paused using the death penalty. So it's geographical at a state level, and it's geographical at a national level.
Interesting. I think the last 3 or 4 death penalty cases have come from outside those geographic centers in Idaho.
In terms of the southeastern Idaho,
2 in southeast Idaho, and I recognize one was death penalty was taken off the table for reasons outside I suppose not ultimately outside the control of the state, but because of the state's failure in discovery. This case, I believe there was
Lori
another one
Bell.
up in the 2nd district relatively recently that then was resolved.
yeah, and I can't dispute that still does not eliminate the fact that in Harrison, Dr. Jensen concluded that there was a geographical issue. And in Dr. Cover's study, she made observations about geography as well.
But even she confessed she couldn't make any conclusions based on that.
And that was why I used the word observation. And had she testified, she would have explained her observations regarding that. But it is instructive to see that a study that was conducted in 1995 in Harrison
How often do y'all think we're going to hear Lori Vallow referenced in this day?
has the same results in 2019, even if it's just an observation about geography. One of the things that the Supreme Court mentioned in its decision in Harrison is that they really wanted more information about the data that had been gathered and the reasons that there was a determination by Dr. Jensen regarding that and more analysis. But nonetheless, that was Dr. Jensen's conclusion, and they are Professor Cover's observations. For those reasons, we are asking that you find, based on Professor Cover's study, taking it at face value with its conclusions and providing you with the data that we will look at and redact
If I
names.
go there, in other words, if I accept that there's an actual valid analysis to be done here, would you agree that I need to look at cases since 2019 as well?
I think, Judge, that the point of bringing in an expert today to talk about a study is that that's her expertise in gathering the information and putting it into a compilation. For you to engage in that on an individual basis.
Well, I can't take her opinion because it's a legal conclusion. Looking at her data, which is 5 years old now, it seems to me that if I were to engage in that, I would have to look at the data as of today. And not as of 2019.
Yeah, I guess I'm not willing to concede that. And if it was something that needed to be undertaken, I'd like to have the opportunity to have Professor Cover testify about
She's
her
got no
time
opinion
frame.
about that.
Pardon?
She's got no opinion ultimately about that. She has some data that she collected that she thought was interesting and might require some additional study. I guess the point is, if I were to engage in that, it seems to me relevant, at least as to the state claim for, claim that the state equal protection, not state equal protection clause, but the equal protection as applied within Idaho geographically, would need to look at that as of the time frame now.
Well, it could certainly be instructive, Judge, but if you're taking the data from Hairston, which was 1978 to 1995, and Professor Covers from 2002 to 2019, the data, if it was analyzed, I'm quite certain would support both of their premises. I haven't analyzed it. We could have that study done, but I think that there's enough guidance with all of those years of data to be able to draw the conclusion that it's arbitrary and capricious today, because the statutory language is still, the definition is still the definition. The statutory aggravators are still the statutory aggravators.
I have a case that indicates that an equal protection analysis can be applied on its face as opposed to as applied, because my understanding is an equal protection clause has to be analyzed as applied.
Yeah, I'm not able to, I can't right in this moment give you that case. I'd be happy to look into that and submit it as a supplemental authority.
You would agree if it is as applied, that would put your client's claim, at least as it relates to within the state of Idaho, as not being problematic, given that he's from one of the smallest districts in the state.
Well, then I want to go back and talk to you, Judge, about the premise in Hairston, which was pre the Capital Defense Fund, which also has created, in time.
3 juries, how does that work? That's wild. Yeah, Superior Court's not uncommon. Like, I think like in North Carolina, the Superior Court is like our Court of Appeals. Like a lot of states will have that. It's just sort of a terminology thing, but typically like the Superior Courts can be like on the trial court level or like on the appellate level, depending on the state. And no, I can't imagine that. I was not a fan of John Pryor personally.
Another dynamic of whether or not someone's charged with the death penalty and those costs at the time that he was charged. I mean, now it's different. So yeah, I'm not going to concede that as applied, it just simply doesn't fit. I think that there are greater questions than that, but I don't have a case to point you to exactly. I don't think that has been, it hasn't been raised in Idaho. We're making the first equal protection. In other district court cases in North Idaho, Mr. Logsden has raised this issue. So I don't want to say you're the first, right? But it hasn't made it to the Idaho Supreme Court, to the appellate courts.
I just don't see how, as applied, you've provided the court any information where I could conclude that because your client is from one of the geographic districts you claim is the does not get its fair share of capital cases.
And we did not submit that argument in our brief.
Thank you. I think you've used your time.
Thank you, Judge. I'll try and keep this brief. I think there are two problems, independent problems with the theory that the defense is articulating here, and they both come from Idaho Supreme Court decisions. The first, as this court has noted, comes from Hairston, where the court said, this just isn't how you do the analysis. You don't cumulate them and then do
What's
the analysis.
intellectually wrong with that analysis, though?
With cumulating and then,
I mean, I understand the legal cases may not be supportive of the defense's claim, but from an intellectual analysis, if the point is to make the death penalty less arbitrary,
correct.
why wouldn't you look at the net or the cumulative as opposed to each individual compared on its own in isolation?
So, Your Honor, I think to answer that question, looking back to kind of how this was developed with the aggravating factors, the idea behind the aggravating factors is that you have to be able to show that this person is morally worthy of the death penalty. And so if you have individually analyzed every single...
You just hit the nail on the head right there. Morally worthy of the death penalty. So whenever I think about this thing, right, I've posed the questions. I'm like, well, the death penalty is not going to save, it's not going to make it any safer for the public, right? It's known, it's been known for years that it's not actually a deterrent to prevent crime. There's really no actual reason. When people, if they're if someone were to say they support it, and you were to ask them why, there's no actual I don't even know what they would say. But there's not you can't really give any supporting evidence in terms of statistics or whatever that show it has a positive impact on anything, literally, as a society or as a human race. And I'm going to back it up because I want to make a point with his specific wording here. Hold on. I need to make sure I get it right.
Net or the cumulative as opposed to each individual compared on its own in isolation.
So, Your Honor, I think to answer that question, looking back to kind of how this was developed with the aggravating factors, the idea behind the aggravating factors is that you have to be able to show that this person is morally worthy of the death penalty.
Right. That's the whole thing. So that's the whole point. So the fact that that's what it comes down to. What it comes down to is how does someone deserve it? And they have to be more morally worthy of it. Well, that sums the whole thing up in terms of how this is vague and subjective and arbitrary. Because the question is how would you determine if someone's morally unworthy? You can't just say, oh, well, how do we deter? It's the question is hey, how do we narrow it? Well, give us the worst of the worst. Okay, well, what's the worst of the worst? Well, they have to be morally corrupt or morally worthy of the death penalty. Okay, well, what does that mean? How would they be morally worthy of the death penalty? Well, they have to be heinous, atrocious, and cruel. I mean, it's just, but I think that the bigger picture here, the reason that it's caught my attention especially is because it sums it up in the sense that the only way that people could advocate for the death penalty is for moral purposes, because there's not actually anything concrete in terms of positive impacts it has on anything. There's only long lists of negative impacts. And isn't it so ironic though, right? Because it's I don't know, hypocrisy. All right, I'll be quiet.
And so if you have individually analyzed every single factor and every single one you found constitutional, then it doesn't matter if in every case you could apply one of those factors, because that factor is a reason why that person is morally worthy of the death penalty. And so it's not an arbitrary and capricious system. It's not left to the whims of somebody.
But if you have so many aggravators that on the whole would essentially apply to any first degree murder, then isn't it just left essentially to the prosecutor as to which cases are or not worthy to bring as a capital case?
Yep.
So absolutely, the prosecutor would have a lot of discretion in that. I don't know that I agree with the characterization that it's left to the prosecutor, because of course the prosecutor has to prove that aggravating factor beyond a reasonable doubt. And if they can prove one of those aggravating factors beyond a reasonable doubt to the jury, and the jury finds that, then that person is now worthy of the death penalty. And again, when we instruct the jury, we don't instruct them to consider.
He rightfully so almost seems to struggle to get that out.
all of the aggravators in the aggregate. We tell them you have to consider them individually. We tell the state's required to present non-duplicative evidence for each aggravator that it's going to assert. You can't just throw out a blanket of aggravators. I think focusing on single aggravators is consistent from beginning to end of our entire system. And so I don't see a problem with that analysis that the Idaho Supreme Court said that that's not how you do this. And I would note, I think the court has mentioned this as well, it's not just the Idaho Supreme Court. There are many courts who have rejected this approach. The defense hasn't been able to point to a single court in any state, in any jurisdiction, that has used this cumulative approach to attack the death penalty or the statutory scheme of the death penalty in any state. So I think the court was right in Hairston. Clearly, it's binding precedent. The defense in their reply brief, they tried to say their response to Hairston was, well, that was when judges were doing the determination. And I just don't see the relevance to that, logical or otherwise, how that would matter on the narrowing part. They point to Hidalgo, which they brought up multiple times today, which is a dissent. It has no binding authority. It has no effect whatsoever on the case. So they just can't point to anything to say that Hairston doesn't apply today. It does apply.
Right now, we're hearing from some dude. If you see the banner on there, by the way, I have it as a ticker just so it doesn't cover them up as much of the screen with the way they had the layout here. But right now, it says motion to strike the collective death penalty aggravators. And then where I also have whoever is speaking or arguing, it says some dude from the state. I just wanted to say, I'm not trying to be rude. I just don't know his name. I've not heard anyone say his name. He's not done a whole lot of arguing. He did a little bit early on when this thing first started, like a bazillion years ago, back in the olden times. So if we hear his name or someone hears his name, please let me know. I will gladly, add it with his actual name. But that's why right now it's some dude. Some dude is this fellow, because right now he is arguing on behalf of the state.
Apply today, and the Idaho Supreme Court has rejected that approach. So that's the first reason why this fails. But then even independent of that, there's a second reason. And that is the defense is relying on this narrowing process that has been described by the United States Supreme Court. I believe the most recent case that they've kind of walked through that was the Tulipa case. And in Hall, our Idaho Supreme Court talked about Tulipa and exactly what that test requires. And they were analyzing a single aggravator because that's how you do this. And it was the court acknowledged that, yes, this would apply to many, many murders, but it doesn't apply to every murder. And that's all that Tulipa requires.
Tulipa sounds like an ice cream flavor to me.
So the way, even if it were appropriate to aggregate all of these circumstances, the appropriate narrowing question is, does it literally apply to every single murder? And even Professor Cover's analysis shows it doesn't. It's a high percentage, but it's not 100%. And so it would pass the narrowing requirements of Tulipa as interpreted by the Idaho Supreme Court, even if it were proper to aggregate these together. Your Honor, in terms of the equal protection claim on geography, I think, here again, they run into a problem with the Idaho Supreme Court. A similar claim based on geography was raised in Hairston, and the court rejected it. The court not only rejected it, the court instructed future defendants, if you want to bring this claim, here's what we're going to need to see. And they said, in order to show that the imposition of the death penalty in Idaho is arbitrary and capricious, there must be some empirical evidence connecting the discrepancy that appears to be shown by Dr. Jensen's study and one or more impermissible factors. And the defense has been aware of that. And instead, they bring a study where the person who conducted the study acknowledges, I can't show that. That it's just not sufficient. It's not sufficient to make any kind of, at best, they've shown a statistical discrepancy, and that is not sufficient to claim some kind of constitutional violation, any kind of constitutional violation. I want to end just by talking a little bit about the court's question on, would you have to look at the data up to today? I think the question or the answer to that has to be yes, absolutely. There's no reason why the date Professor Cover conducted her study has any legal relevance or significance. It would be up through today. And I think this goes back to a problem of this whole accumulating the aggregating factors and then doing a mathematical study and finding the percentage, because let's say that courts engage in that conduct, and let's say that courts decide it's 50% is the magic number, and if you get above 50%, then your statutory scheme is unconstitutional. Well, what if Idaho is right at 50.5%, so it's unconstitutional, but then over the next year, a bunch of murders are committed and none of them satisfy the aggravating factor, so now we're at 49.5%. Now everyone in that year can be subject to the death penalty because the murderers that committed murders that year decided to do it in a way that didn't satisfy one of the.
Alternatively, you could just choose to not kill anybody that year. Just another thought. Yeah, it sounds like we're going to hear from them later, but I mean, oh, right. But that's different though, because, okay. Yeah. So when you like thinking of like 3 juries, I thought you meant like at the same time. Like the Menendez brothers had 2 juries. That was kind of a unique situation though. But are you saying that like with the 3 juries, is that like a common thing and they're all in the same room? Or was it because there were 3 defendants maybe? Like similarly to Menendez? But
Aggravating factors. I don't think there's a logical basis for that. And I think that's why the Idaho Supreme Court has taken the approach they have, where this isn't a quantitative analysis, it's a qualitative one. Is there any narrowing that's being done? And if the answer is yes, then you've passed the test. That keeps things fair and uniform across the state and temporally across time. And so I think that's another reason why it wouldn't make sense to aggregate these. Unless there are any questions, we'd ask the court to.
You want to address the geography issue?
Yes, Your Honor, I addressed it briefly. I'm happy to talk about it more from the Harrison decision.
Well, it's not necessarily a requirement you do so. I just wanted to know. You were a summary about it, and it seemed to me the defense had raised some issues that perhaps were a little more expansive than what they had argued in their brief. And so
I would certainly agree with that, Your Honor.
oh boy.
A couple of things on that. First, the idea that it somehow violates equal protection for Idaho to apply the death penalty when other states do not on a national basis. I'm not aware of any case law that would support that. And in fact, it's direct.
Don't think they said that. Correct me if I'm wrong, but I don't think they made that argument.
Directly contrary to the case law that we're going to talk about later on evolving standards of decency, where the U.S. Supreme Court has specifically acknowledged that, yes, there are some states that apply it and some states that do not. The conclusion from that isn't that just because there are some states that do not apply it, it's unconstitutional everywhere. So I don't think that that's an appropriate question. In terms of within the state of Idaho, I think to the court's point, with an equal protection analysis, really the first question you have to ask is, who are we talking about and what status do they have or what position do they hold? Because a critical part of the equal protection analysis is you have to treat people that are similarly situated the same. You don't have to treat people who are not similarly situated the same. So that initial determination of are they similarly situated requires a subject, a person. And so to the court's point, I think in the vast majority of cases, at least that I'm aware of, equal protection is raised as an as-applied challenge, as applied to the person bringing the challenge. And so in this case, where they're trying to argue that it's only the larger counties that seek these things, as the court pointed out, that's not true in recent Idaho history. And they, again, have not pointed to any study, Professor Covers or anywhere else, that shows that the reason why there are more death penalty cases brought in the larger counties is because of some unconstitutional reason, rather than could it be explained by something else, like the fact that they are more appropriate in those areas. And frankly, the common sense understanding would be that you're probably going to see more death penalty cases in more populated areas, because just as a matter of statistics, there's probably going to be more first-degree murders committed there, and therefore probably more that are eligible for the death penalty. So certainly they would have to rebut that with some kind of evidence that shows, as the Idaho Supreme Court told them they had to in Hairston, that makes a direct connection between empirical evidence and some impermissible factor. And that's just missing here. Unless the court has any other questions, thank you, Your Honor.
rebuttal.
Judge, I just wanted to touch on the issue that he raised about Harrison and the timing of that, and the fact that at that time when that came down, judges were doing the imposition of death penalty sentencing. And that really is a very important distinction, because as you know, the arguments that are coming up in other motions, the difference in an experienced judge being able to get into all of these nuanced areas and apply beyond a reasonable doubt in the gateway phase, and then just mercy in the mitigation phase is very, very different. Tulepa that's in the statute that we don't have. Whether or not the offense was committed while the defendant was under the influence of extreme mental or emotional disturbance. clearly not something that's in Idaho's aggravating statute to consider. Whether or not the victim was a participant in the defendant's homicidal conduct or consented to the homicidal act. Whether or not the offense was committed under circumstances which the defendant reasonably believed to a moral justification or extenuation for his conduct. A statute that, frankly, those types of terms in our statute would be very welcomed. And I wanted to also point out that the study dates amount to between 75 and 95, those years in Hairston, in 2002 and 2019 for Professor Covers. That's 37 years worth of data with the same definitions. So, instruction in a few more years of data, you've got 37 years to rely on, that there's no narrowing. Thank you.
You know what year the Capital Defense Fund was established?
It was after 95. And I think that Hairston may have been the impotence for that. If Mr. Logsden was here, he'll be here later. I think he knows the exact year of that. But I don't. I just know it was
Has that
after
mitigated the
95.
issue in your mind?
Pardon?
Has that mitigated the issue in your mind?
No, I think that it has not. It has not. And I frankly think that the new system with the state public defense is going to make it worse. I think that there will be no reason for the state not to charge death in every first degree case, because our statute doesn't prevent them from. Everybody fits. Everybody fits.
Thank you.
All right, I will take the issue under advisement and issue a written opinion. It's 10:30. I'm going to take a 10-minute break, and we will adjourn after that.
All rise.
All right, court will resume shortly. How about now? How does that sound good to you guys? Let's zoom through this. That's funny, the message though. This is new. I like that the courtesy message. Very official look. It's got the little state of Idaho thing. They got really lucky with that logo because of the fact that an eye looks like a pillar. Actually, let me pull my banner down so y'all can see it better. See here, they got lucky with that, the letter I. Anyway,
Motion to strike.
okay. So we're going to see what we got coming up next. All right. Oh, okay. Okay, gotcha. Right. That makes sense that does make sense if it's different defendants, co-defendants. I just feel like it's not, I guess in general, I feel like it's less often that you have co-defendants, at least if they're co-defendants, especially in being tried at the same time. That's just pretty unusual. I feel like co-defendants period is pretty unusual for majority of murder cases, but especially it being tried at the same time. So.
All right, I think we are on now the motion to strike the individual statutory aggravators.
Yay!
And I will give each side 25 minutes and you can address them
He's going to give them a time.
in whatever proportion you like.
Wow, interesting. Here comes Miss Massoth again. Look, she looks very excited.
Okay, Judge, I will be covering heinous, atrocious, and cruel
All
out of
right.
disregard.
So,
And then I will do multi-murders, and Ms. Taylor will do future dangerous. So I'll basically do the next three.
all right.
And given the time that you've asked, I'm assuming there will be less questions.
I
maybe?
will try to restrain my curiosity.
Right. I'm happy to engage with you.
I, as you know, I gave you some additional time, and that says why.
Right,
Why?
thank you. We are asking that the court strike the aggravator, especially heinous, atrocious, and cruel, manifesting extreme depravity. And I want to focus, I think I just want to start really focused on how this is different than Hall. We're aware that Hall, Arabay versus Levitt, there's a lot of discussion about having addressed this aggravator before. We are framing it for you in our argument in a different way. And so what I want to show are the distinctions is that, Hall was a decision was issued in 2018. So was Hidalgo. So when Hall issued their decision, the arguments hadn't been framed in light of what we just argued about Hidalgo and that eligibility narrowing. Also, there was no equal protection argument, no argument regarding Article 2, Section 1 of the Idaho Constitution. One of the cruxes of this argument is that what the Idaho Supreme Court and the Idaho courts do with this aggravator is they've created a jury instruction that is construction, also known as, and called in our briefing, judicial gloss. Our argument is that Osborne is from 1981. That's when the judicial gloss was applied, and then recently the Idaho Supreme Court adopted and adopted instructions related to this. But what happened in 2011 is that the Idaho Supreme Court issued the Verska versus St. Alphonsus decision. And in that decision, the court said, this court has consistently adhered to the primary canon of statutory construction that where the language of the statute is unambiguous, the clear expressed intent of the legislature must be given effect, and there is no occasion for construction. And the courts have not taken that into consideration. So if the statute is unambiguous, then it should be given its direct meaning, which we quoted in our brief would be heinous means utterly odious or wicked, atrocious means horrifying, wicked, and cruel means willfully causing pain or suffering to others or feeling no concern about it. And if it is ambiguous, then under Verska, the judicial gloss should not be allowed.
If it is ambiguous?
If it's unambiguous, then.
So RICO. Okay. So like when I was saying that you rarely ever hear of cases where there's or I rarely ever hear cases with multiple defendants. I was saying that like I should have put a little star, a little asterisk there, saying with the exception of RICO cases, of course, right? I don't put those in the same category. But for anyone who's not really familiar with the RICO, so RICO is the what does it actually stand for? Let me see. Its origins were federal. Okay, it's really more for organized crime. Doesn't have to be murder. So, racketeering, running weapons, that type of thing. So it's based on so RICO stands for the Racketeer Influenced and Corrupt Organizations Act. So I think it kind of started out like mobs and shit like that, right? Drug trafficking, human trafficking, kidnapping, money laundering, that type of shit. Mail fraud, wire fraud. It can apply to like pretty much anybody, but the whole point is it's that like it's a law that enabled law enforcement, federal law enforcement, to go after like a large number of people and charge them as part of an organization. So what's interesting though is that it's like I said, it's a federal law, but not all states have their own RICO laws. So let me see here. Yeah, it's not, I mean, it's rare. And that's the thing. That's where it was surprising to hear of it, in Georgia. It was a big deal. It's a big deal that they went for that. So it's kind of like trying to take down the mafia, so to speak, in a way, right? Again, thinking of like a criminal organization. That's literally what it's designed for. And that's, again, why it makes sense with federal cases, right? Like the description I just read to y'all. When you're talking about the feds, yeah, they can take out the mafia, the mob, but they can take out these, you know what I mean? Or they, whatever. They have the resources. They have the manpower. So you can see why it's like, I remember when I first heard that there was going to be a RICO case coming out of Georgia, I was like, what? Come again? Pardon? I'm confused because I was like, how? But that's what's happening, and we're seeing how well that's going for them. So but I don't think North Carolina has one. I'm just going to double check and see if I can get a concise list here of the states, but it is rare, period, for states. And yeah, I have not been able to quickly retrieve a list, but yeah, so there, hopefully that helps answer your question about the RICO racketeering.
And the judicial gloss should not be allowed. But what, the state is arguing that it is, has not argued that it's an ambiguous statute, because that would give us grounds for the argument that it should be stricken from as an aggravator as arbitrary and capricious. And so we are asking that you take into consideration the way that we are framing this argument, which is different than
Difference
it was
between
in Hall.
Ambiguous and vague.
Pardon?
Difference between ambiguous and vague.
I don't know that I can necessarily draw just a distinction there. I think that they're, similar. Yeah.
Well, so let's do all of yours, and then we'll do all of theirs. I think it goes faster that way. If we do this back and forth, I think it takes longer. They can take notes.
That's kind of a rude question.
So utter disregard falls under the same argument. The one thing that I want to point out about utter disregard is that Idaho is the only state that has that as an aggravator. But when you look at other states, there's language that is found that is the same as heinous, atrocious, and cruel, which is interesting because it looks like almost we have the same aggravator labeled as two different things. And we also raised the argument there that it's a separation of powers violation when there is construction on that statute, and that violates VRSCA. The next one that I am going to cover is the multi-victims aggravator.
Now, this is the one out of the 4 remaining aggravators that I think, obviously, I don't think there's, if Bryan Kohberger is found guilty, I don't think there's any question that there were multiple victims, right? This is the only one that, to me, holds any water in terms of meeting any type of narrowing standard and being objective. The other 3 are so problematic in my mind, not just in my mind, on paper. But the multiple victims, okay, fine. That isn't that, I will say, that does narrow the pool, because not everybody kills more than one person if they're found guilty. Well, kills more than one person and then is found guilty, shall we say. That does narrow the pool, which is what is required for them to start going after this. So, yeah, anyway.
Idaho is the only state that has both a multi-victim and propensity aggravator. A multi-victim aggravator is clear. We were having that discussion between clear and fuzzy. Multi-aggravator is clear. 1 + 1 = 2. The irony in some of that is that it seems to lessen the value of a single human life, but it still doesn't tell us anything about the culpability of the person who has been charged with the crime.
Well, isn't it more culpable to kill 2 people than 1?
I think that the issue is, the problem is that it is.
Isn't it a morally more problematic, the number of lives you take?
I think that it depends on, first of all, I want to start answering that question by saying any life taken.
I agree. And
Right.
and the
But-
floor is pretty high. But what I'm saying, doesn't that bring you above the floor?
I think that it depends on the underlying facts of what is the result, what's the basis of how multiple occurs. And so, just to say that the number of people relates to culpability, I think that what the argument that we're making is that supports the other aggravator of propensity. And under Idaho's, the method of selection with a jury and the rules about double counting, while the jury can take into consideration the same facts for multiple aggravators, there must be more than one fact per aggravator so that there's not double counting. And that is the problem when you've got a multi victim aggravator and you also have a propensity aggravator. And there's been, as we cited,
Is that a constitutional problem or an evidence problem?
it becomes a Eighth Amendment constitutional problem when a jury has an inability to properly distinguish between those issues in finding aggravators beyond a reasonable doubt.
I mean, as the gatekeeper, I assume that if the state hasn't provided additional evidence that would support propensity that is not included within the multiple murders, then that aggravator wouldn't go to the jury, right?
Well, I mean, we would hope that the gatekeeper would do that. Yes, Judge, we're asking you to be the gatekeeper now and prevent us.
Gatekeeper. It sounds like the board game's about to start here. Good night, Flash, and thank you for being here. Awesome to have you. Hope to see you tomorrow night for the next installment of Casey Anthony, and hope you have a good one.
From even getting to that question because of the problem that is identified. And we provided the court with law review articles where the issue has been studied about how impactful multi-victim facts are into the ultimate decision regarding aggravators. I also wanted to point out that there are multiple states with a multiple out of aggravate that have that multi-aggravator, but they don't have future dangerousness, which Ms. Taylor will talk about. And that is very related to propensity. And those states are Alabama, California, Kansas, Montana, Tennessee, and Utah. And in fact, Texas is a good example of it's a part of the definition of capital crime. And then the jury has to decide on the aggravator of propensity after that has been included as part of the narrowing in the Texas statute. So for those reasons, we'd ask that you strike the multiple aggravator as well.
Oh, she was quick. All right, Amy Taylor up.
Your Honor, we're asking the court to strike the aggravator of future dangerousness or propensity, whichever label we want to put on it, but it's found in subsection I of 1925-19, subsection 9. And I think when we're thinking about the constitutional way this is laid out to be protective of the Eighth Amendment, to have a true narrowing, and it can't be vague. We've been talking about that all day, so I won't go into that again. But with that in mind, I want to read the words of this aggravator for the court. That the defendant, by his conduct, whether such conduct was before, during, or after the commission of the murder at hand, has exhibited a propensity to commit murder, which will probably constitute a continuing threat to society. That language does nothing to narrow. That, I'll skip right to the vague part of the argument. We're asking the court to consider three things in striking this aggravator. It isn't narrow, it's very vague, and it doesn't go to the culpability of the crime that's been charged and, if this happens, convicted of. Your Honor, this language, I think, has been acknowledged by our Idaho Supreme Court as needing the gloss in Creech. And I would say that what's required is that the statute, which Idaho doesn't have, has to provide the narrowing or the sentencing structure, and those things are legislative processes. And that hasn't happened. We have the gloss from the Supreme Court. The gloss that the Supreme Court has put on this, though, does not do anything but loop us back to the statutes that define murder and then exclude voluntary manslaughter. If truly we are to have an aggravator that selects out the worst of people who have been convicted of murder, this does not do that. The language in this aggravator is incredibly vague. When you think about really what is going to happen in front of a jury, they're going to get all this evidence that is supposed to be proven beyond a reasonable doubt. I trust the court will instruct them on that. But then they get this evidence that probably will make them believe that person's a future danger. The chance for a jury to misunderstand the call and the burden that needs to happen is really great by the language alone. And Creech really doesn't do anything to help. The gloss that gets put on, the jury instruction that gets put on, that doesn't help. That just says people.
Hall say that it was okay? I can't remember if they addressed that in Hall. I think they
I think
did.
Hall did say it was okay.
So what am I to do about that?
You are to listen to that, allow me to make my record, which I am, but you were to say nobody else has talked to me about the real language in here when it says probably. That is confusing to a jury. This isn't a judge's call any longer. But this is confusing to a jury to have those words in there. And the chance to find this aggravator, either based on one of the other aggravators, which we know cannot happen, or at a lesser burden because of the word probably, you're to find that is way too vague. And you should strike this aggravator because of that. Additionally, while we're talking about vague, there's a lot of potential for the jury to misuse mitigating factors and make them into future dangerousness aggravators. And I
Isn't
think
that the truth, the possibility always in sentencing? I mean, one man's aggravator is another man's mitigator. And I think you pointed it out well in your brief.
Hey,
you know,
that's what I
right?
said in one of the live
Um,
streams. It's a joke.
But isn't that the nature of individualized sentencing and the consideration of those factors?
I think it is a danger. And I can't square in my mind how I am to do my ethical duty to my client and to abide by the guidelines that are set forth in capital cases and do an investigation into mental health and then turn it over like Idaho says I must, and then subject my client to the state's expert to grill him for however long. I mean, I have this duty. My client has the right to present this, but now I have to do all of this and give all of that information up so the state can use it in an aggravator that says, just tell me that the person will probably be dangerous in the future.
Hmm.
That is just terrible, Judge. And for that reason alone, you should strike this aggravator. The last comment I'll make is that future dangerousness doesn't go to the conduct, the culpability of the conduct that has happened. And that's really what these aggravators need to do
Right.
to narrow properly the scope of who's who. I can't tell you the number of times I've sat in court and listened to a prosecutor talk about at sentencing that my client or my client's acts are the worst they've ever seen.
Right.
And that can't be true when you sit in court day
Yes,
after day after day.
How many times have I said that? Boy, I've said it all the time because it just really annoys me when you hear this in every trial when they say that. This is the worst I've ever seen. And it's like, yeah, but I mean, it's not just people just always say that, right? Like that's the thing. And like I guess I hear it oftentimes in the context of when another case, there's a case, right? Whatever the case is, there's plenty of cases, big case, any case, right? And people like in chats and stuff will be like saying, you know, boy, if any case should have a death penalty, it should be this case, whether it has it or not. Most of them don't, right? As we know. So, but you know that like when assessing how bad is a case or how bad is a suspect, I guess really, it's even worse. It seems like one of the ways to test that out is to think to oneself, you know, I'm speaking about just what I see generally, right? Is to but it's to ask like oneself, like, oh, well, would this be death penalty worthy? Like, even if death penalty isn't even eligible in the state, right? Which is, it's like stacking arbitrary upon arbitrary there. But anyway, my point is like, and then if you take that one step further, it's like, how would they, what would make them decide, well, oh, this is the worst case I've ever seen, right? How many times have y'all seen that in any case, in any chat, with any trial? This is the worst case I've ever seen, followed by, or proceeding. If any case should get the death penalty, it's this case. I mean, almost verbatim. I'm sure I'm not the only one who's seen that too many times to count, or many variations of it. And it just annoys the crap out of me because it's not possible. And that's exactly, again, this goes back to the narrowing. That exactly is the point that they were making earlier. It's the perfect example, right? If they're all equally as bad, we've not narrowed it. But it's just interesting that she's now making that same point, because this is something that has been driving me crazy for a long time when people say that. And it's like, well, you know, A, that's so arbitrary, B, that's so vague, and C, like, there's always going to be something else that comes out that will have something about it that might at some point in time make it worse in some way, but you can't imagine that way. And anyway, it's just, there's no cap, right? There's just no cap. Basically, like, I don't think there's any way to definitively say for once and for all, this case is the worst case ever. I just don't think it's possible. There's just too many, there's just no way to do that. So, you know, anyway.
Day, and you hear that about person after person after person. This statute doesn't do anything to help a jury decide who's the worst of the worst. This aggravator absolutely has to be struck. It's a violation of the 8th Amendment.
Thank you.
Now we're here from Speedy again. Love her jacket. Update.
Your Honor, beginning with the heinous and atrocious and cruel, this aggravator specifically has been upheld by the Idaho Supreme Court, and specifically the judicial gloss placed on this aggravator in Osborne.
Was
Now-
Hall a jury determination? You know,
I'm not sure on that, Your Honor, off the top of my head. I apologize.
I think it was, but I don't recall specifically. Notwithstanding the fact that I think that I'm the actual judge on the case now, I don't recall because that issue hasn't come up. But
Thank you, Your Honor. And I apologize. The defendant has raised this argument that in Verska, the Idaho Supreme Court's decision stating that the court would not rewrite or void an unambiguous statute is essentially the same thing as stating that the Idaho Supreme Court is saying that we can't put a gloss on a statute. But those two things are very different, because placing a gloss on a statute to ensure its constitutionality is not the same as rewriting or voiding a statute. If Verska is taken to that extreme, then courts can't interpret statutes at all. And that's not the holding of Verska. Verska simply stood for the proposition that the court was declining to rewrite or void a statute. And of course, the Idaho Supreme Court has never rewritten the heinous, atrocious, and cruel aggravator or the utter disregard aggravator or any of these aggravators. They've simply placed a judicial gloss. As to the future dangerousness and propensity one, which was the most recently addressed, that too has been upheld by the Idaho Supreme Court in State versus Creech. The propriety of considering future dangerousness has been upheld by the United States Supreme Court in Juries versus Texas. In their propensity argument, their future dangerous argument, the defendant is essentially asking this court to start with a proposition that a jury is not going to be able to follow the court's instructions. And of course, we can't start with that proposition because juries are presumed under Idaho law to follow the instructions that they're given. And that is another issue. That issue is also true in the defense's multiple victims argument. Their argument with multiple victims really doesn't cite to any case law. It's simply based on the fact that they're assuming that a jury is unable to distinguish between propensity and multiple victims. And again, the court is being asked to start with the presumption that a jury won't be able to follow the law. And that's contrary to the state of the law. We can't presume that because juries are presumed to follow the law. Additionally, we also can't start with the presumption that the state is going to just put on the same evidence for all these aggravators. The court should also assume that the state will put on independent bases for each of these aggravators during the penalty phase. That's our legal obligation. And the jury will be instructed as to what the law is. They will be instructed that they can't double weigh or double count. That's very clear in the case law. The state would just ask that the court decline to presume that the state will present the evidence in a way that's contrary to law and that the jurors then won't follow the instructions. But that can't be, Your Honor. So the state would ask the court to deny the defendant's motion as to these aggravators. All of these aggravators have been upheld, specifically the HAC along with utter disregard and future dangerousness. There is case law directly on point that is binding on this court. We would ask the court to deny their motion.
thank you.
Judge, to answer your question about Hall, Hall was originally sentenced by a judge, and then the sentencing was retried, and Mr. Chastain and Ms. Christensen handled that case.
My memory came back to me between then and now, so thank you for clarifying that.
Yeah. I want to point out that Verska says if it's socially or economically unsound, the power to correct is the legislatures, not the judiciaries. If it needs fixed with construction, as we argue that it does, it must be stricken. And I want to address the question that you asked about why not wait until the evidence comes in and I can strike the aggravator at that time. It goes to the point of why we are arguing all of these right now. There's a huge difference between picking a death qualified jury and a non-capital qualified jury.
Well, but that just went to my point of your argument presumes I would strike all of them. If, for example, I were just looking at multiple murders versus propensity and do those two so overlap that you can't have both, you could still have one, or you could have both. But if there's not evidence independent of one, then you would strike the one.
So you're correct that we are asking you to strike all of them so that we don't have to pick a death qualified jury, because death qualified juries are highly likely to convict in the guilt innocence phase. So we are very, very concerned about that, and the fact that that is so different in a death penalty case. But to the extent that you might strike some and save one, for example, the multi aggravator, there's a vast difference in what happens in front of the jury in the selection phase with that aggravator versus the others that we are asking you to strike. Thank you.
Thank you.
Your Honor, I certainly didn't mean to tell the court that I would presume whatever jury we end up with won't follow the law.
Yeah,
What I'm
right.
saying
For
is
real.
that particular statute, the future dangerousness statute, is really tricky. It's tricky because of the use of the word probably. It's tricky with the rest of the wording too, and based on the information that will likely come in. I point out that when it was up to a judge to decide, I think a judge is well versed in what does beyond a reasonable doubt mean and what is a probability. The court looks at that all day, every day, and those are hard concepts for a judge.
Standard would be that the jury would have to be convinced beyond a reasonable doubt that it is probable that the defendant would be it's probable that they would kill again. I think it's the way that washes out.
I think that's the way it washes out too. And I think it's just a problem with the word probably in there.
I mean, and I agree with what she's saying. There's another whole issue to me that, just on principle that, the fact that this aggravator is saying the likelihood that they would kill again, like propensity, right? Future dangerousness, it's future danger to the public. And no one's been able to answer this question for me yet thus far, every time I've asked, which is, how does it protect the public more to kill somebody versus giving them LWOP? How does that protect the public more? How is it that to say they're extra dangerous and they're going to be an extra danger to the public? So to protect the public, it's going to be extra protective to the public, like public benefits if we kill them versus life without parole. Like how? It's really crazy, right? Like when you really think about it, it's like crazy that this is even a thing. Like this is even an aggravating factor, a statutory aggravating factor for the death penalty, because just the mere premise of it doesn't make any sense unless you were to say that the prisons are just like they leave the doors wide open, right? Like anyway.
So when a judge was doing this, it was less of a problem. I still think there's issues with that particular aggravator. And I would point out that the higher courts in Idaho have recognized the problem. That's why the decision in Creech put a gloss on it. And I think when the courts recognize that that's a problem and there needs to be a gloss or a fix put to it, that's one thing for the court to consider. How the fix was done, I think, is a problem. It's a jury instruction, not by the legislature. But keep in mind, there's a problem with this instruction or with this aggravator. It needs to be fixed. But the fix is to loop back to statutes that already exist. And I don't really think that's a fix. And I'll stop there.
What's up next? Yeah.
All right, I think the non-statutory aggravators is the next issue for our attention. So with that, I'll hear from defense.
Thank you, Judge. Your Honor, by way of housekeeping with the non-statutory aggravators, I understood the state's response briefing to say that they agree that they have to provide notice and any discovery about non-statutory aggravators as well.
They said that they would, is what they had said they would.
Yes. So I think I don't have to argue about that. I think I'm limited to arguing about the burden of proof required for non-statutory aggravators.
Arguing for the state on that issue.
Yeah, Your Honor, the state's position is that the statute clearly says that Rule 16 applies. We agree Rule 16 applies and we'll comply with Rule 16.
All right.
I'll limit my comments then to burden of proof. Your Honor, our position is that non-statutory aggravators need to be proven beyond a reasonable doubt as well. We know that the state can use non-statutory aggravators to help them establish aggravators beyond a reasonable doubt. And looking at the court's new jury instructions that just came out, beyond a reasonable doubt is all over those. When we're talking about aggravators, there's no question there. Those jury instructions are silent on non-statutory aggravators. So I can't lean on those to say that the court should find that these have to be proven beyond a reasonable doubt. But from a fairness standpoint and from a it just makes sense standpoint, you should say they have to be proven beyond a reasonable doubt. I'm thinking about this in the context of having a jury and having the prosecutor producing evidence and arguing beyond a reasonable doubt, but having these other non-statutory aggravators and say, these are things that we have that you should consider, but we don't have to prove these to you beyond a reasonable doubt. I think there's a real danger in a lack of confidence in the finding of an aggravator if you don't require them to prove the non-statutory aggravators beyond a reasonable doubt, just like their statutory aggravators. Capital cases are a really big deal. And if we're going to get all the way to the end of this, and that's where we're at, the court has to have confidence in what's presented to the jury. Mr. Kohberger has a right, if that's where we end up in his case, to have a jury finding any single aggravator they might find beyond a reasonable doubt. And we think you should order the state to meet that burden if they're going to present non-statutory aggravators.
Thank you, Your Honor. I want to start by just, I tried to be very careful in my brief to refer to it as non-statutory aggravating evidence, because I'm not sure what a non-statutory aggravator is. I want to be clear, the state's under no impression that there's some shadow list of aggravators that it can prove one of those and that qualifies the defendant for the death penalty. We are, of course, required to prove beyond a reasonable doubt one of the statutory aggravators. And I think what we're talking about here is just non-statutory aggravating evidence. So evidence that may not be, and if I'm being...
So if you look at it like a scale, right? And the defense puts on evidence of mitigation, and the state has to put on at a minimum evidence beyond a reasonable doubt of a statutory aggravating evidence. When you go to weigh, does your non-statutory aggravating evidence go on the scale when that weighing is done?
Yes, Your Honor. And I think that that's clear from the Hall decision when they talked about this. They talked about the Zant decision from the United States Supreme Court and how it's important that juries understand when they're making that, when we get to the individualized determination of is death appropriate in this case, it's important that the jury have
I'll tell you guys right now, even though they haven't said the word yet, what they're talking about right now is going to come up again when they get to what the thing that I'm looking forward to the most of this day's proceedings, which is the motion to trifurcate. This non-statutory aggravating evidence, in summary, it comes down to this: victim impact statements. That's what they're talking about. Now, I've talked at great length about a lot of this in the previous live streams covering all of these different filings, so I just don't want to be redundant, which is why I'm not pausing the hearing to speak so much as to the background of what was going on with the documents and the implications and, even terminology, whatever the case may be. I just, again, to hopefully not be redundant, but of course, if y'all have any questions, feel free to ask and I'll be happy to answer them if I can. But I just wanted to note that this non-statutory aggravating evidence essentially is victim impact statements. That's what it is. And we're going to hear this come up again. Everything they're talking about now, this is like a snippet. This is going to be discussed, I'm sure, at length when it comes to the motion to trifurcate. So.
Wide array of information. That's the purpose of the statute, is what the Idaho Supreme Court said. So yes, I think at that point, any aggravating evidence that has been presented goes on that scale. Now, to be candid with the court, in my mind, anything that's relevant to a statutory aggravating factor isn't non-statutory aggravating evidence because it's relevant to the aggravating factor. And just to be frank, I can't even come up with a good example of what the state would put on in this case that would qualify as not relevant to an aggravating circumstance, but relevant to the overall weighing process. I guess my point is, I don't know that this is going to be an issue, given that we will, of course, comply with discovery. We will provide everything that they'll know what we're going to say before we say it. And if there's an issue, we can raise it at that time and discuss, is this actually relevant to a statutory aggravator or not? And if not, does it fit into what I consider to be a very narrow category of non-statutory aggravating evidence that is still somehow relevant to the overall decision, but not one of the aggravators?
I think the visual using my scale would be to get on the scale, the statutory aggravating evidence would have to have been proven beyond a reasonable doubt, right? That is, you have the existence of that aggravator would have to have been proven beyond a reasonable doubt. As I understand the non-statutory aggravating evidence, the existence of that evidence would need to be proven only by a preponderance of the evidence. Is that your understanding?
You know, I don't know that I would completely agree with that, because I don't know that that's laid out in the instructions that it's to any specific burden. I think if you look at the jury instruction 1722 on jury deliberation, it talks about finding the statutory aggravator beyond a reasonable doubt. And then when it gets to weighing, what it says is you must each decide for yourself whether all mitigating factors presented when weighed against each statutory aggravating circumstance proven by the state are sufficiently compelling to make the imposition of the death penalty unjust. You do not have to unanimously agree upon what mitigating circumstances exist. The existence of mitigating factors need not be proven beyond a reasonable doubt. You must each decide for yourself whether mitigating circumstances exist, and if so, then consider them in your.
Y'all keep this in your minds. This is where there begins to be this conflating of statutory aggravating factors, statutory aggravators, right? And mitigating factors. Because that he's just brought that into it. He's just thrown that in. He's just thrown the monkey wrench. Because I remember when I covered these motions, I was really confused with the state's response to what the defense said when it came to the motion to trifurcate. And I was like, what? Are they confused? Like, what is happening? And they kept bringing up mitigating and stuff. And I'm like, are they really confused? And it's happening again here. It's very odd. Like, he's supposed to be making a distinction, as per the judge's question. He's supposed to be making a distinction between the burden of proof and how it is explained to the jury in the jury instructions, the burden of proof when it comes to the statutory aggravating evidence versus the non-statutory aggravating evidence. But instead, he's comparing statutory aggravating evidence to mitigation. It just doesn't make any sense.
Individual weighing process.
Right, those are the mitigating.
Correct, but I think what I'm getting at is that's what we have in terms of the instructions of this weighing. Is it's saying to the jurors, you're going to conduct kind of an individual weighing process to decide whether it's just or unjust in this circumstance, and that's the point where these things would come on the scale, to use your analogy. And so I just don't know that there's a point where you would instruct the jury. You heard from witness X, they said A, B, and C. You can only consider that if you find that A, B, and C is true beyond a reasonable doubt. I don't see an instruction for that anywhere. I don't think that's typically how you do sentencing. They would put on their mitigation. Maybe we have some rebuttal to that mitigation that you might consider non-statutory aggravating. But then again, it specifically tells the jury you do not have to find mitigating beyond a reasonable doubt. So my point is both in the mitigating evidence and in this
Now he's back to the mitigating. What is going on
statutory aggravating evidence, there isn't a standard that's given to the jury. And I think that is what was intended by the instructions. And we could debate whether that's the right call or not, but I think that's what the statute calls for. I think that's what the instructions call for. And I think that's the process that we should follow. Recognizing, of course, this court's role as a gatekeeper as to what gets heard at all. The fact that we'll be complying with the rules of discovery and they can bring up any objections that they want beforehand. I don't know that this will be an issue in the case. Unless there are any other questions, we would ask that you deny the motion. Thank you, Your Honor.
Your Honor, I would start by saying I thought I heard the state get really close to saying they're not planning to produce any non-statutory aggravators or non-statutory aggravating evidence, whichever way you want to talk about that, which might be really good. It might save the court having to make the decision if they get all the way there. I would say, though, there's not a statutory list of non-statutory aggravators. But in Hall, that decision talked about things in a person's background, if they had a prior criminal history, things about their character. And a prior criminal history, that's fairly definitive. Either you have one or you don't, right? Mm-hmm. But things about a person's background, that's where it gets really questionable. Are we talking about people's opinions, people that maybe would have an axe to bear with the person that they're talking about? So I think that when you consider what Hall talked about as a non-statutory aggravator, it becomes really important that the state have the burden of proof of beyond a reasonable doubt for those. I would just close by saying that Gardner versus Florida talked about why we have notice and that reliability matters. but it's the same thing on this kind of information, this kind of evidence, these kind of non-statutory aggravators that get produced. It has to be reliable, and the court has to be able to rely on what a jury comes up with. And Mr. Kohberger has a right to have information come in fairly, to have notice of that information, and for the state to carry the burden. And they need to carry the burden if they want to present non-statutory aggravating evidence. Thank you.
Thank you. All right. You're okay with it. I'm going to swap 8 and 9, just because I could see 8 potentially going a little bit longer than 9. And so, well,
Your Honor, can
Yeah.
I help on that?
yeah,
If the court takes the first part of 9, the speedy trial issue, that's the one I'm handling. And I think we've got Jay that's ready on the rest of them. We can cover it, but he's really close.
so he's not here. All right. Well, let's start then with 8, contemporary standards of decency.
That's the one that Mr. Logsden
Oh, he
would
is.
be here. I've got Speedy.
Would you have, who has trifurcation?
Jay is the one that's the most prepared on trifurcation.
So you've got Speedy. Let's start with that then.
I can do that. Thank you, Judge.
All right, speedy trial it is. This is going to be interesting because we know he waived it.
Your Honor, we're asking the court to strike the death penalty in this case based on a conflict of constitutional rights and Mr. Kohberger having to face the choice between holding on to one constitutional right at the expense of another. And that's what's happened here. He has had to choose between his 2 constitutional rights, and those were effective assistance of counsel or speedy trial. Mr. Logsden wrote the brief on this, and he did a really good job with the history and why we should look at Idaho's speedy trial, constitutional guarantees of speedy trial in the same time frame that the statute 1935-01 says. I'm not going to go into all of that again, because really this is about the choice of picking between constitutional rights.
It seems to not to go into the history that your argument essentially asks the court to equate what the pre-constitutional statutory standards were as then constitutional standards. And I think the court has said that that's not the case. Am I wrong about that?
I'm not sure I'm following what the court's asking me. I'm
So
sorry.
it seems that you're asking the court to equate what the statute said about speedy rights before the Constitution, Idaho Constitution provided for it, and treat that as the constitutional standard and grafting it into the constitutional standard.
I would say that it's there to provide guidance because there was that the statute we have now is after the Constitution. The territorial statutes were before we had the Constitution. And when Idaho wrote its Constitution and said, we guarantee defendants a right to a speedy trial, there was that already in mind. I don't think our Constitution says it's 6 months to the day and it's over after that. I don't think that at all. But I think that what was a speedy trial would have influenced a speedy trial right. I do not think our Constitution says it has to be 6 months, but I think our statute does now, and our statute derived from an older statute. And I think that statute, well, I know that statute predated our Constitution, and I think it influenced the writers of the Constitution to as a guideline. as a limit.
Framers,
We also know that speedy trial you can go beyond the statutory time frame, and you can stretch that out in different circumstances for different reasons. And our argument is less about that. That's not the argument. The argument is the choice that Mr. Kohberger faced in August of 2023 when he had to choose to continue his case, thereby giving up his speedy trial rights, or go to trial in October.
I just had to say, because all this, when I said shout out to the framers, just got me thinking about Jay Logsden. And I was like, man, I'm surprised we're not having Jay Logsden argue this one too, because this is like right up his alley with like the framers and the history. And then I was like thinking, I'm so excited that we're gonna get to hear him argue these motions here when he arrives. Oh, shout out to Kat Randall. Happy to see you. Did you change your font again? It looks like here. Having a cat nap. Wonderful, wonderful. This is some great bedtime material as always. Just, a couple death penalty motions here and there. Also, I did come up with a name for this new judge, Judge Hippler. I'm right now calling him Judge Grinchler because we have Prosecutor Santa and then Judge Grinchler, because so far he's been quite the grump, it seems like. the grouch.
October 2nd of 2023, 10 months after being charged with this case, with completely unprepared counsel. And that's really the crux of this argument. And the remedy is for the court to strike the death penalty because Mr. Kohberger had to choose between rights, reinstate Speedy, and reset a sooner trial date. That's the remedy. I want to talk about what happened and why Mr. Kohberger had to continue his case. The
Like,
court's already heard a little bit today about
all the death penalty motions, of which there's like a bazillion, y'all know. This is the one that I was like, I couldn't even believe that they filed it, to be honest, because like there was so much discussion about this at the time when, which waive or to not to waive, that is the question, right? And it was like so clear on the record, like, okay, if you waive it, da da. And when I saw this, I mean, those of you who saw the live stream, I think I like laughed out loud, like when I pulled up, I had all these PDFs, so I didn't know what they all said, right? They'd just come out. And then when I was flicking them out one by one as I went through them, and then I got to the one and it said speed trial, I couldn't even believe it. I couldn't believe my eyes. I was like, this is incredible. But it's happening. But anyway, of all of the different motions related to the death penalty, I was like, yeah, this is not going anywhere. But they are doing their job and being super thorough and arguing everything they can. And I don't blame them for that at all. It's what you got to do. I mean, when you think about it, it honestly takes even more like skill and talent to be able to argue something that doesn't really have any good points you can make about it. And when ultimately, it's not going to go anywhere. Like when you know that the motion's not going to go anywhere and there's like not really any good points you can make about it, it's actually even more impressive when you can still argue for it. So like, and somewhat well, like in terms of just the ability to even say words, essentially.
out the duties of counsel in a capital case
Like
and the
she's
kinds of
doing.
investigations we must launch immediately. It's not just about the facts of the case, but it's also about the facts of the case. But the mitigation phase has to be launched whether or not you ever end up with a conviction. That work has to be done. That's the way it works, and it takes the time to do that. You have to find experts, you have to find records, and it takes time to do those things as well. So and discovery can be a really big deal. And I think the court is probably starting to understand just how big of a deal that is. Last August of 2023, when we were in that place where we had to make that decision, and there was a scheduling order from the prior court in this case that told us you have to continue it by this deadline, by this date, or you can't continue it and you're just going to go to trial. So I think we're positioned a little bit differently when we are truly in a place we have to give up one right to have another right. Had Mr. Kohberger gone to trial and stood on that right, his speedy trial right, and lost his right to effective assistance of counsel, there would have been more than a year's worth of discovery that his counsel would have not been able to know about. We have continued to get discovery. I think there's a bit more that continues to trickle in even past the deadline. I'm not arguing about that right now, but it's just a vast amount of information that Mr. Kohberger would have not had counsel prepared for. We do not have a mitigation investigation completed. We're in process with that still, a year and 2 months after that deadline. So he would not have had that to benefit him either. I think one of the most important things the court should think about when we think about Mr. Kohberger having to choose between his constitutional rights is that we're here right now,
Yay!
because he couldn't get a fair jury in Latah.
Yay!
And if we'd gone to trial in October of 2023, he would have maybe held on to his speedy trial rights. Well, he would have held on to his speedy trial rights, but he would have given up his right to effective assistance of counsel and his right to a fair and impartial jury.
What's wrong with the idea of speedy evolving on a sort of good cause basis? I mean, capital cases at the time the Constitution was adopted were tried within 6 months, right? The standards of how to try those cases were obviously different. And as more contemporary thoughts about that have arisen, it's become the standard that they require more. And so why wouldn't speedy be flexible to accommodate that?
Well, I don't know why it would or why it wouldn't, but that's not been what's happened. We don't have a separate criminal rule that says that. We don't have a separate statute that says that. We would bend the Idaho Constitution until it breaks to make it say that. I'll give you kind of an example. During the time of COVID, when the Supreme Court told the speedy trial rights, It did that based on a national emergency. Court orders were issued. I am not saying whether I agree or disagree with that, but that's something that happened. And I think one of the cases the state cited in its response brief, State versus Ish, I think that particular case had 422 days of time between when the remediator was issued and when the case went to trial. And that person asserted their speedy trial rights that whole time. That happened during COVID, when the court had its emergency orders during that whole time. So I think to say, well, it's a capital case and they're a lot different than they used to be, and they are, and they're a lot of work and they take a lot of time and investment, they do. But there's nothing that's been changed in our Constitution, in a court rule, in a statute, to say if it's a capital case, speedy trial, really, you just don't have that right. A person facing the death penalty just doesn't have that right. All of those rights exist. They all exist right now. And Mr. Kohberger had to choose between those rights. I think the court can and should strike the death penalty in this case based on the
Well,
record
that would
here.
result in the death penalty being struck in every case.
Your Honor, if that's the way it is, because our clients collectively in the state of Idaho, when you have a capital client, if that's the case, then that's the case. I mean, we have been
The
doing this.
Constitution is flexible enough for the Supreme Court to itself say, well, we can pause that right, and we can expand that right based upon the circumstances, i.e. COVID. Why can't it expand the time that speedy is measured by constitutionally, given that evolving standards have required more time to present a capital case and measure it against that?
I would say that I don't know whether they can or they can't, but they have not. And that's the critical area. I would say the Supreme Court probably would believe it could do that, but it has not done it. And I would say they would believe that they could because they did so during COVID. But that hasn't happened. That has not happened.
So you think that the Supreme Court would likely say, well, as opposed to interpreting the constitutional right more broadly to apply over the be more flexible given how the defense of capital cases have evolved, they would be more likely to say, well, we're just going to not have any capital cases, period.
I don't know if they'd say that or not,
Well, that's what
but
you're asking me to say.
I'm asking you to say that. I'm asking you to do
My job as
what
a district judge, if there's not an issue that has been decided by the court, is determine how that court would decide things.
Well, I think you can consider what Judge Boyce did in the Vallow case, and that had to do with discovery that counsel didn't have enough time to review and to prepare for, and it would have disadvantaged the client. And so Judge Boyce in that case struck the death penalty.
That was as a result of the state having failed to provide the information, violating its court order. And then the remedies were, well, do we push trial back or not? And the choice that Judge Boyce gave the defendant was, well, we can go to trial, but I'll remove the death penalty because a lot of the discovery related to that. Or we can continue the trial for you to review that. But so you can either go to trial with the death penalty, without the death penalty now, or you can expand it with the death penalty. One defendant chose one and the other defendant chose the other. But in this case, the decision to waive speedy was not as a result of, as I understand it, a violation of a court order by the state.
It was as a result of a court order. And when we waived speedy, we advised the court and counsel that this motion this day was coming. We don't think it's appropriate to force somebody to choose between competing constitutional rights. Lori Vallow had not ever waived speedy trial. And so she had the choice to waive speedy or not face the death penalty. And we think that since we were forced to choose between rights, those should be reinstated and the court should strike the death penalty.
Thank you.
Thank you, Your Honor. So not only can the Idaho Supreme Court do that, it's already done it. The Idaho Supreme Court has said that we interpret Idaho's Constitution for speedy trial the same way that the federal Constitution is interpreted under Barker. There's one exception that has no application here. And so it's an individualized test based on 4 factors, and you're really looking at kind of the overall reasonableness of the delay. I would direct the court specifically to the Langford case that just came out last year. The Idaho Supreme Court walked through the difference between the two constitutions, explained how they operate, and then found specifically in that case that they charted out how many delays they were, what the delay was for, who caused the delay, and then was it reasonable or not. And they found, they said, in sum, most of the delays here were precipitated by Langford's own actions. In the case of the last and longest continuance, the delay was reasonably necessary to allow new prosecutors and new defense counsel time to prepare for trial. So they found that's a reasonable, under the Constitution, that is a reasonable delay. So there is no choice here. You don't have to choose between speedy trial or effective assistance of counsel. You can have both. I think what the defense is saying is they've lost their statutory right to 6 months, which they do lose if they take an action to delay the trial at all. But that's not a constitutional problem that they have to give that up if they want to maintain their constitutional right to effective assistance of counsel. Now, in this case,
Well, and that was my point in, perhaps not well stated, is that it seems what this defense is trying to do, and perhaps you can comment on whether I'm seeing this correctly, is to engraft what was the territorial law, which is that a case had to go to trial within the, at that time, courts were held in sessions, calendar sessions, right? I think there were 2 sessions a year or something like that. That was the speedy right. And then we had the Constitution that doesn't, necessarily give us such a fixed time frame. But the argument is, well, because that was the territorial law at the time, therefore that's the constitutional right. And it is engrafting that statutory construct to mean the constitutional right.
potentially, Your Honor, though I'm not sure that's exactly, because my understanding of the pre-Constitution statute was that it was based on kind of the circuits and when they came, and we don't do that anymore. And so that time frame just doesn't make sense today. You wouldn't be able to just engraft that in the Constitution and apply it today, because
My point is that's, I think, what this defense is arguing, essentially.
yes, Your Honor, but the statutory right they're pointing to comes from the new statute that was passed in 1980 that gives the 6 months time period. And regardless of whether they want
Argument that the 6 month is functionally equivalent of the twice a year circuit.
if that is the argument, I don't think that it gets past the Idaho Supreme Court has said, no, it's not. So, under the Idaho Constitution, we use the Barker test. The crux of the matter here is that the defendant didn't have to waive his constitutional right to a speedy trial. He did. He did so under advice. He did so in writing. He did so knowingly, but he didn't have to. The trial could have been continued, even at his own request, without him waiving that right. He waives it statutorily by moving for a continuance or to ask for more time to prepare, but he does not waive it constitutionally. If he did, then most of this Langford analysis would have been completely unnecessary. But instead, at the end of the day, when you do finally get to trial, the reviewing court looks back and breaks out segments of time and says, whose fault was that delay? And as the court said in Langford, many of the delays were because of Langford, and so they don't count against the state. But the court easily could have said, well, he asked for a delay, so his constitutional right was waived. They didn't, because that's not how it operates. So the real problem here, I think that the defense is grasping with, is that they didn't need to waive his constitutional right, but they did. So, there's not much the state can say other than that wasn't required. The Constitution not only can be flexible, the Idaho Supreme Court has held that it is in fact flexible. And one of the reasonable, a proper reason for delay is to prepare for trial. And that means this is not a choice that has to be made by any defendant. It didn't have to be made by this defendant, but he chose to. Unless there are any further questions. Thanks.
Just briefly, Judge, we're not trying to graft in a time into the Idaho Constitution. We're looking at the word, the guarantee for a speedy trial, and trying to figure out what the word speedy means. And so
Why doesn't speedy mean the Barker test?
at the time the Constitution was written, I don't think it did.
Isn't that what the Supreme Court has said it means?
I think our Supreme Court does agree that it's the Barker
Again,
test.
I think I probably can dispose of a number of motions by simply saying that the defense asks me to do X. Doing X would violate the binding precedent of the court. Denied.
I think if I was here saying dismiss the case based on a speedy trial violation, I think that's exactly what the court would do. This is a little bit different. We're asking for the court to set the case back to the point where we had to choose between constitutional rights and to strike the death penalty. In our case, this is the last point I'll make. In our case, we signed a waiver of speedy trial, and it was a form, I believe, that was generated by the court. It was signed on August 23rd, 2023. Mr. Kohberger signed it, and I assigned, with the parentheses, attorney for the defendant. And in that form, and remember, our scheduling order said you have to do it by this day, or you don't get a continuance, you just go into trial. We gave up the right to, under the United States Constitution and the Idaho Constitution. And I have a printed copy, but I know the court probably has the entire court file. That's it.
All right. That, along with the other motions that will be taken under advisement. Let's take a lunch break. It's 5 to 12. Adjourn at 1 o'clock. Thank you.
All right, another one going under advisement and lunch break. I do love this new thing they got going on here with this like friendly looking screen. So let's take a look and see here. We'll resume shortly. Thank you, thank you. So the trifurcation is the thing, like I said, that I'm really looking forward to, most especially here to see what they say about this. Oh, wow. So I guess they got like a new YouTube handle now. Or no, sorry, they don't. So it's the Idaho 4th District Court, whereas before it was Judge's channel. All righty, here we go.
You can be seated.
See Logsden?
All right, we are reconvened in the matter of State versus Kohberger.
Can we hear about
Defendant is
Magna
present.
Carta, please?
Together with counsel, I would note for the record that Mr. Logsden is present as well. At this point, the state is present through its attorneys. I think next we started those categories that I identified as the 9th topic. We'll continue with those and then circle back to the 8th. So let's talk about the state's concern about the grand jury not having considered the aggravating factors. Next. Mr. Logsden.
Your Honor, apologize for not being able to be here earlier for proceedings, Judge. I overbooked myself today.
You're here, so that's fine.
Your Honor, as to the argument as to including the statutory eligibility requirements for a death case in the grand jury, I think the two major hurdles that we have to get over are, one, the Hurtado case not requiring the grand jury to apply to the states. And then the second is the ruling in Abdullah that essentially said you don't need to provide these to the grand jury.
Seemed like a good place to start.
It is a good place to start. And as we tend to do in these cases, because they are going to go up on appeal, we are of course asking that those things be overruled. Certainly recognize your Honor doesn't have the ability to do that, but we respectfully make the argument that those cases were wrong. We also make the argument that there is another way to get there. So the Fifth Amendment obviously is the grand jury amendment, and I think Abdullah was looking at the Sixth Amendment or notice requirements and what needed to be included there. We furnish an additional argument that the Eighth Amendment in death cases requires additional process. And we see that largely in what occurs at the sentencing hearing, but we also see it in things like requiring counsel before it was required for anything else was required in death cases. We also see it in requiring the state of Alabama to permit a lesser included instruction so that a jury can choose something besides something that would lead to
Let me
death.
ask you a question about that. So on the one hand, as I understand your argument, it is that the grand jury should be required to not only find an aggravating, statutory aggravating factor, but also that the grand jury then weigh it against mitigating evidence. Is that your position?
No, let me be clear. As we would talk about in the trifurcation motion, I'm only talking about the statutory aggravators, not the non-statutory aggravators or the mitigators. It would simply be
Your brief says otherwise. So that's why I question that, because as we've learned, that takes a long time for those things to be developed. That's not necessarily evidence in the pocket of the state. What is now gone from a case timeline of several months to now multiple years would seem to me to even drag it out longer.
And I certainly understand that concern. I don't think that that's our position. I certainly do believe that the law would require the state to put on mitigating evidence if it had it, because that's something that they're required to do by law. They're required to put on evidence if known to them would possibly point in the direction that the person is innocent, et cetera. But I don't think what our position is that the state would be required to put on essentially their entire sentencing hearing in front of that grand jury. The grand jury is still only just determining whether or not there is a reason to go forward with the case. Our point is that at the time of the founding, that grand jury would have known that all felonies lead to the gallows. So at that time, the grand juries were making decisions about whether or not people were going to face the death penalty. And it wasn't until the Supreme Court after Furman in the 70s that we came up with this entirely new system. But it's one where the grand jury has lost its part of its function, where it's looking at whether or not these people should be facing the death penalty or not. Essentially, they were deprived of that through the transition that was obviously intended to protect people from an arbitrary infliction of the death penalty. But the grand jury itself is supposed to also have a role in that. It's supposed to protect people from arbitrary decisions. And so that's essentially what our argument is that there should be a neutral fact finder placed between the citizen and the state when we're making the decision whether or not the death penalty should be sought. And so that is one of the reasons we're asking the court to strike the death penalty in this case. Does the court have any other questions for me? Thank you, Judge.
Neutral fact finder. Let me get my done.
Your Honor, sounds like on Abdullah, this is just a issue of issue preservation, so not much to comment on that. In terms of this other argument that they are saying you can look at it differently through the Eighth Amendment, keep in mind the Eighth Amendment is just the prohibition on cruel and unusual punishment. It's quite a stretch to jump from there to requirements on what needs to be presented to a grand jury. The Beck case that they cited suggests that maybe there could be a connection if it diminishes the reliability of the sentencing determination or the guilt determination, but that's not the function the grand jury plays. And so for this court to stretch the Eighth Amendment all the way back to the grand jury would be.
In fact, with respect to failings of a grand jury to pass on a particular element, for example, if there's then been a trial, the general standard on appeal is, well, the matter went to a jury and they made the determination there's proof beyond a reasonable doubt, and therefore any error is moot.
Correct, Your Honor. And I think really that gets to the heart of this claim, which is it's just kind of another way of their argument that it shouldn't be the prosecutor deciding that a notice is filed. And the U.S. Supreme Court has said it's not a problem if the prosecutor has unfettered discretion in who gets the death notice and who doesn't. So that by itself isn't a problem. So unless there are any other questions, thank you, Your Honor.
Thank you.
You know, if we can say nothing else about Jay Logsden, one thing we can say is he does love the grand jury. He loves the grand jury. Still don't know that dude from the state's name, so he's still going by some dude for the time
Any
being.
rebuttal?
Yay, Jay's back.
Well, I think it would be best to push back at least a little on the idea that the Eighth Amendment can't go back that far. I mean, recall that it was the Eighth Amendment that required that there be counsel for people that were facing the death penalty. Now, I certainly understand the idea that the Eighth Amendment's concern is that we have a reliable procedure. I certainly understand that. But the grand jury, it does fulfill.
I wonder who these people are. Because whenever it shows, it doesn't show it a whole very often, but there's more people sitting on this side behind the prosecution table. I mean, obviously there's still plenty of room, not like it's, sometimes, obviously when it comes to trial, that matters. I don't know if there's any rhyme or reason to it, but I did see, it looks like there's maybe some of the victims' family members. I'm just curious if these are just people who just, came and sat on the side or, what the dealio is. It looks like most of the media, and reporters and whatnot are over on the side with the prosecution. So
some of that function as well. And besides,
we'll never know.
At least if we're speaking in terms of what was understood to have a grand jury and what it did at the time that the nation was founded, it would have been stepping in a case involving a possible death penalty and being able to put a stop to it then and there. And so I do think that the Eighth Amendment has the ability to attach even that early on, at least in cases involving death. And then I recognize that there are these cases from the Supreme Court indicating that prosecutors do not have to have anybody determine whether or not they can file the death penalty and that they can drop it out of a sense of mercy. I think that's a slightly side question to, if they choose to go forward with it, who can stand up and say, before we spend years on one of these cases, that this is not the appropriate case, someone besides the prosecutor, which is what we have with grand juries and preliminary hearings, et cetera. And so we still believe that the argument here is one that can be passed on by this court and that hasn't necessarily been ruled on by these other cases that we also think should be overturned. Thank you, Judge.
Thank you.
I believe I have all the remaining
All
arguments,
right,
so
well,
whichever the court would like
let's
to.
finish up topic 9 with your contention that the death penalty should be struck because it violates international law.
Thank you, Your Honor. So that motion is largely premised on the International Convent of, I'm gonna have to pull it up. Sorry, it's the ICCPR. International Covenant on Civil and Political Rights. And so essentially the argument comes down to this. We have signed and ratified a treaty that would put, we think, additional requirements on what we would do if we're going to have a death penalty in this country, and obviously we have one. One of those is a requirement that we make sure that we're not arbitrarily killing people. And the other one is that people are not being essentially tortured.
My understanding is when the time that that convention was ratified with the understanding that to the extent that it is agreeing to anything, it is agreeing to afford the 8th Amendment protections.
That's correct, Judge. And I think to some extent, what we're arguing is the 8th Amendment and the ICCPR work together, and that we can look at these international obligations and the 8th Amendment and say that they essentially are the same thing. That's why we talk about.
Well, I think you're looking at it from 2 different prisms. I think what the state is saying, to the extent that this covenant applies, which is questioned about whether it's self-executing and all the rest, it only governs to the extent that the 8th Amendment, apart from that, would have protected that situation. Whereas what I think you're arguing is that the 8th Amendment must be read to be broader as to what international law would dictate.
I think if what we're saying is that the state would argue that we read the 8th Amendment and that's what the international law must be, we're saying you have to read the international law to decide what the 8th Amendment.
So you're having the international law dictate what the United States Constitution means.
Correct. And we are doing that on the basis of what the United States has said itself about the fact that they believe that they live up to these things, and the fact that we have,
Oh
we
boy.
discussed the charming Betsy canon.
Yo,
which
hold
is
on.
Obviously a very old canon.
Hold on. Let me back that up. I somehow accidentally muted my microphone. This part is insane. Jay Logsden's
National law to decide what the 8th Amendment.
So you're having the international law dictate what
he's in the danger zone, I would say.
United States Constitution means.
Here, that question. Hold on.
And that's what the international law must be. We're saying you have to read the international law to decide what the 8th Amendment.
So you're having the international law dictate what the United States Constitution means.
Correct. And we are doing that on the basis of
Danger, get out now.
what the United States has said itself about the fact that they believe that they live up to
Completely fearless, Jay Logsden.
these things, and the fact that we have, we discussed the charming Betsy canon, which is obviously a very old canon and typically is just about whether or not our statutes are in line with our treaties. But I think particularly in this case, where the United States has essentially said, we signed on to this treaty because we live up by these same standards that everyone else does. We can look at what the international community thinks about those standards that we said we also abide by when we're determining whether or not we're living up to the standards in the Constitution.
Y'all, I wish I could zoom in. Look at this face. This is really how he looks all the time, pretty much. And I brought it up at the beginning of the stream. So far, the lighting, exactly the same. Literally everywhere else in the courtroom, everybody looks pretty good, like normal. And then the situation, and always with this, I guess, a scowl, would you call it?
And
But what they said specifically is that we think that we are living up to those, even though we have and will enforce a death penalty.
and I think, which is why
I'm not trying to be mean. It's just the reason I was bringing it up is because I always put the judges and the attorneys in the thumbnails, right? So when Judge was removed from the case, I had to take him off the thumbnail. And then I was like, I think at one point I had a question mark. And then when they assigned a new judge, I was like, yay, I can finally put another judge back in the thumbnail. And I was like, I can't get a freaking picture of him that looks human on a thumbnail. So I was looking forward to this hearing for many reasons, but one of them was I was like, well, maybe that was just a fluke and the lighting it can't possibly be as bad this time around, right? Like he can't possibly be that unphotogenic for like an entire day of hearings, because the first one was really short. Well, I was wrong. So far, I was wrong, because we're nearing the end, and so far I'm not seeing any opportunities yet to where I can get him on the thumbnail. So.
We're not saying necessarily that the death penalty would be struck if it was done properly. Our argument is that the way that Idaho has its scheme set up, there are far too many statutory aggravators, and some of them are just big enough to drive a Mack truck through. And so just about every murder could be charged with and have the death penalty.
Aha, not enough
And
heroin.
so that doesn't require the narrowing that we've said we're going to provide.
Yes,
It
indeed.
certainly doesn't live up to what the international community would expect from us.
Yeah, I understand the argument.
Well,
Falling up, I'll be frank, it's falling about as flat as you would expect it to fall before our Supreme Court or
Oh,
the Supreme
boy.
Court of the United States.
well, you're all right. It's an argument and it must be made. So
You need to make a record.
thank you, Judge.
Well, good sport, I guess. That sucks. At least Judge would like bother to like think it through and not just be like, yep, this is how it's done. Too bad. Bye-bye. Like Judge would like be like, all right, let's talk this out, because he would always find, instead of just relying on this is how it's always done. Like that's what I loved. Y'all know I loved Judge. One of the many reasons is because he really he had that more of that philosophical mind, which I adore. And instead of just relying on, well, this is it, that's how it's always done. Too bad, so sad, just whatever. He was like, let's actually think this through. And he, even with stuff that was like, just as, what the whole thing with the other things that Jay Logsden was saying with the grand jury, right? Like, that the initial burden for a grand jury is beyond a reasonable doubt. Like, it's just, stuff like that, or stuff that just is like so black letter law, but like, Jay Logsden would come in with this like crazy long motion recite, going back to the annals of history. And Judge would go there with him and be like, all right, well, let's rethink it through. Like, in other words, I'll go there with you, and they would discuss it. And what was great about it is that what would happen is through going through the legal analysis, right? What are the arguments? What is the case? Like, literally just hashing it out. Like, they would still end up with the conclusion that the initial, the initial law was sound, or the initial finding was sound. But that's so much better and more productive, in my opinion, than just like, well, this is how it's all done, and not actually bothering to understand it. You know what I mean? So I appreciated that. I appreciated that he took the 10 minutes to like, let's go through and let's okay, presuming what you're saying is correct, and then and like thinking it through. Versus just, oh, all right, we're done here. I don't know, but that's just me. I know most people didn't like Judge. On to the next.
Unless the court has any questions, I'm okay.
I don't, thank you.
All right, moving on to the next one.
All right, let's talk about the contemporary standards of decency.
Thank you, Honor. So I think the main case for this one was Roper v. Simmons. Wasn't confusing it with Atkins, but essentially the court has said that when deciding what contemporary standards are in terms of what's cruel and unusual, that the court first looks at what the state legislatures are doing and then makes a decision based on its own determination of what it is it's going to be. But when we look at those cases, they also look at other things. They look at international law. They look at what religious organizations are saying. I mean, they're obviously looking for what's the consensus going on.
I think Idaho Supreme Court said is what we look at is legislative and governmental determinations and actions.
That I think I think that's Abdullah where they had said that, and I think that was partly because the way that it was. And in those cases,
Couldn't hear you.
it seemed like the record that was brought up to them was somewhat sparse. And so hopefully we've provided more information than they had at those times. But in those cases, the number of states that still allowed the death penalty, I think, was around 35. And as the court, as we noted,
Oh, I
that number has-
pointed this out and I covered these because I was really surprised. Some of the statistics they provided were really surprising. And I thought interesting and noteworthy, like the difference in how many states had the death penalty. I think this data was like 2015 versus now. And that's what he's referencing. And it was it was just pretty fascinating.
dropped somewhat precipitously since that time.
Yeah.
Those would be the legislative activities. I think what I was, I guess, taking issue with is the idea that they would look to what religious and other sort of non-governmental advocacy groups would argue or accept.
Well, I can only say that Roper definitely looked at international law. And if it wasn't Roper, then it was Atkins. But the one about children and whether or not they can face the death penalty, they definitely looked to international law. And so I don't think there's anything that says that the court can't look at whether or not organizations have moved against the death penalty. We are becoming somewhat alone in the world in terms of continuing to make use of the practice. The number of states that are still doing it is shrinking. And so when you look at that total fabric, it's our contention that we've reached the point where the death penalty really ought to be abolished. And so that is our contention in this case. Thank you, Judge.
Thank you, Your Honor. While Roper may have looked at some international law, I think the Idaho Supreme Court has really narrowed that window. First in Abdullah, they said, therefore, absent some legislative or executive action, a determination by this court that Idaho's death penalty statute is unconstitutional based on evolving standards of decency and public opinion is unsupported. So they're really looking in at that. And fast forward 5 years in the Hairston decision, 2020, the Idaho Supreme Court reaffirmed that view and then also said, quote, we continue to subscribe to the view of legislative bodies as the basis for determining a national consensus. And so, and the reason for that, they explain in Abdullah, is that courts just aren't good at taking a temperature of public opinion and what represents society's views. Now, looking at the states that have capital punishment, according to the resources both sides have cited, there's 27 states that still have it on the books. That's a majority. They've pointed out that there's gubernatorial moratoriums in 6 of those, which is true. But that means worst case scenario, there's 21 states that still have the death penalty on the books and can use it. And what the Idaho Supreme Court said in Hairston is that we're looking for a national consensus. And we're nowhere near a national consensus that the death penalty is somehow immoral or improper or indecent. I would also just note, it's not enough if what you're trying to show is a national consensus, it is not enough to just point to the fact that a state doesn't have the death penalty. You would have to show that the state removed the death penalty because that state believed that it was immoral or improper. So for example, if a fiscally conservative legislature just decides they don't want to fund the death penalty, but they have no moral objection to it, that's not evidence that there's some societal standard that would.
What do you take of evidence from a state who is not enforcing the penalty because, for example, an executive of that state is morally opposed to it and has the power to preclude it from being applied? Should that be considered?
So the Idaho Supreme Court did mention executive action, although in Hairston, they seem to say that the better picture is painted by legislative bodies. And I think part of the reason for that is because the executive, it can just depend on the administration that's in power at that moment. A perfect example of that is the United States. The death penalty is on the books. It's currently not being applied, but shortly before the current administration, it was. And I think it's safe to assume that it will be again here shortly. The other thing you have to look at is, why is the executive doing this? For example, the defense cites that Tennessee has currently a moratorium. True, but the governor did that because he said we need to take time to fix the execution protocol. That's not evidence of a national standard that the death penalty is wrong.
So in a state like Tennessee, are they still in the sentencing capital sentences, but just not carrying them out, or have they stopped even trying capital cases?
I can't answer that definitively for Tennessee. My understanding is that they still try them and impose the death sentence, but that it's just not being carried out.
No, I don't think they're actually imposing the death sentence. I actually did with all the filings that we've done and covered with this. I've done a lot of extra research as well, and I did look up every state, and I'm pretty sure, if memory serves, that Tennessee is actually not. That's not being offered as a sentence right now, as well. I'm pretty sure. Oh, spinning wheel, why? Why? Oh, spinning wheel.
I know that to be true, for example, in California, juries are still imposing the death penalty. I know in Ohio, another state that they've pointed to where there's a gubernatorial moratorium, there are 30 scheduled executions in that state. They keep getting pushed back, but the reason they're getting pushed back and the reason for the moratorium is they can't find chemicals to do lethal injection. Again, that's not evidence that there's some standard of decency that's keeping them from doing this. They just can't find the chemicals to do it. So I think,
Well, I mean, you could imply that the standards of decency as applied by the pharmaceutical companies who refuse to take part in it is some measure of that.
potentially yes, but I think again, going back to the Idaho Supreme Court's decisions,
That's a really
we're
good
looking
point
specifically at
from
executive and
Judge
legislative
Grinchler.
action. And the fact that the legislature or governor is saying we would do this, but we can't get the chemicals is actually evidence that they still support the death penalty. So I think no matter how you read the numbers, we're not at a place where there is a national consensus that the death penalty is indecent. And so we think the court should continue to follow what the Idaho Supreme Court said in both Abdullah and Hairston and reject their motion. Thank you, Your Honor.
Well,
Just briefly, Judge, I would caution the court trying to figure out why it is that a particular state either dropped the death penalty or imposed a gubernatorial moratorium. I mean, I think that these things are complicated.
I was thinking the
Looks enough.
exact same thing. When the judge first started going down that road, I was like, why are we trying to read the minds of states? Like, what? This seems not like what we should be doing. Like, why are we trying to, objection, speculation, like for every state in the union? Like, I guess they're allowed to like go ahead for Idaho, I suppose. But like, I was thinking that. And anyway, so I agree with him.
An awful lot like trying to figure out from legislative history why something occurred. Half the time, what you see in the questions doesn't necessarily tell you what the legislature had in mind when they finally voted. And so I think
Like
the first
Supreme
step,
Court.
as the United States Supreme Court has set it out, is just to look at the numbers. And then after that, the courts can consider other things.
or 2021, if you take into account moratoriums. How, I mean, certainly more than a third of the states, how does that represent a consensus?
I would argue that the consensus can also come from the trajectory. So the fact that so many states dropped the death penalty within the last 10 years, and that appears to be the direction that things are going, is something that the court can take into account. I also note a lot of these states that have death rows and don't have a moratorium still aren't actually executing anyone. And so the actual number of executions in the states that are actually executing anybody is less even than that. I think it's something like 13 jurisdictions that are actually doing executions. So anyway, for those reasons, Your Honor, we are asking that you strike the death penalty.
Thank you. All right, I think that leaves us with your motion to trifurcate the proceedings and to apply the rules of evidence in the penalty phase.
Right. So, Your Honor, I tried a case via the trifurcated method. It went smoothly, and we moved this court to do the same thing. If it's not trifurcated,
Which case was that?
that was Renfro.
Which one?
Renfro. If it's not trifurcated, what happens at in the penalty phase is the state would be putting on both statutory aggravators and non-statutory aggravators. I think the states argued that some of those things.
Isn't there a post-conviction
I'm
proceeding in which
excited
it's
about
alleged that that is ineffective assistance to allow the trifurcation because you make the jury decide about whether or not an aggravating factor is there in the absence of any mitigating evidence that might otherwise affect their decision?
I'm sure there is. But I can't say that I agree because from a jury's perspective, I mean, you have to realize that these are people who have been pulled in, they don't have legal training, and now you're asking them to make a bunch of different decisions at the same time. And as
I brought this up earlier. Remember what I said, guys, about there's this whole weird thing about conflating the statutory and then the non-statutory and then the mitigating evidence. And I had noticed this in the filings. I was like, what is going on? Because I don't understand. I just don't know if things are just being conflated or confused. And already we're seeing that same type of issue pop up here with, ineffective assistance of counsel. Like, I'm wondering if what's going on is a miscommunication. And I think this is what I kind of figured out through the filings too, that like, for some reason, the judge and maybe the state thinks that the defense is requesting that the way it be trifurcated is the obviously the guilt phase, and then the sentencing phase would be like statutory aggravating evidence followed by non-statutory aggravating evidence, followed by like sentencing, and then followed by mitigating evidence. Like, hold on, let me just make sure I said that correctly, because it's a lot of words that are very similar. So like the state is maybe thinking that what the defense was asking for was in the sentencing phase for it to be first the statutory aggravating evidence and then the non-statutory aggravating evidence, aka victim impact statements, and then the sentencing, right? Like, and then lastly, mitigating evidence. Like that doesn't make any type of sense. My understanding is, and the thing that makes sense is that they were asking for, let's hear all the statutory aggravating evidence, right? And then let's hear all the mitigating evidence. And then let's have the jury deliberate and return a verdict, or, for in terms of the sentence. And then after that, let's hear the non-statutory aggravating evidence, which is the victim impact statements. That's my understanding, but let's just see what else they
Pointed out. I mean, we can go back and forth about, what's the, if you don't trifurcate, you're going to put on the victim impact during the penalty phase with everything else, right? And so whether or not there's even a statutory
see what he just said is exactly what I thought this whole thing, that it's the victim impact statements. That's exactly it. So I don't know why there's this issue being conflated with where the mitigation comes in. It's very odd to me. But what he's saying is what makes sense for sure.
aggravator is now going to be influenced by all of the things that are emotionally really powerful.
Mhm.
And so, I mean, we can go back and forth about, who does that prejudice? At the end of the day, a trifurcated proceeding is just simpler for a jury to do their job. They have to be able to make a decision about statutory aggravators to even have a death penalty in a particular case. Being able to do that with just a standalone, do these things actually exist first before you start to get into the mitigating and aggravating? I mean, you can put on some mitigating depending on what the aggravator is at the aggravating portion of the case. You can talk about future dangerousness and things like that, assuming that the court decides to let it in. But if you don't do it this way, what you risk is that a jury is going to be influenced by non-statutory aggravators, victim impact statements,
Right.
and on those grounds,
Yes,
say yes to one of the statutory aggravators.
I agree.
And
Yep.
you also are telling the jury, these things you have to find beyond reasonable doubt, but these things you don't, and do all of that at the same time. And I mean, the studies have shown that juries really want to get these things right, and they really want to follow the law, but oftentimes the instructions that they get aren't really that clear. And I think adding to their burden by cramming it all into one hearing, it's unnecessary. The court has the ability, I think, under Rule of Evidence 106, to let them do the function that they're supposed to do with the statutory aggravators, and then that way they can make that decision. And if they don't find any, you don't even have to do the next part. But if they find one, then you open it up into the state's case in aggravation and the defense case in mitigation. In terms of using the rules of evidence, as we pointed out, a number of courts have said, confrontation clearly needs to be able to apply. You have discovery that needs to go out. Rules of evidence are helpful, and they're certainly helpful when you're talking about the statutory aggravators themselves. And that's an area where if you're trying to make a accurate determination of whether or not those things exist such that you can have the death penalty, the use of the rules of evidence is, I think, can be detrimental to both sides if you just kind of allow willy-nilly whatever to come in.
Willy-nilly.
So for the other reasons we put in the brief, Judge, we are asking the court to consider doing this as a trifurcated trial if it gets there. Thank you.
For anyone who missed it before when I covered this document, the rules of evidence do not apply when it comes to the sentencing phase.
And Your Honor, just to briefly address the point about the confrontation clause and the rules of evidence. The defendant has fairly acknowledged in his brief that the Idaho appellate courts have issued binding precedent that's contrary to their argument today. The state's not going to belabor that point. I think the case law is clear and the state briefed that. As to trifurcation, the defense has yet to lay out what exactly this process would look like. And what I mean by that is, at what point it appears, although the defense has not explicitly stated this, that they would encourage this court to adopt a procedure where the state puts on all of its aggravating evidence for all of these statutory factors, and the jury then goes to deliberate on these factors without hearing any of the mitigating evidence. Now, this is very concerning, and particularly the state briefed this. You take the propensity aggravator, where the jury is tasked with determining whether or not the defendant's going to pose a continuing risk, to send them back to deliberate without allowing them to hear evidence and mitigation. That's very concerning to the state about what that might do to, for example, the appellate record. And I think that post-conviction proceeding in the Renfro case really highlights the concerns with this procedure that they're asking the court to adopt. As to the assertion that this is simply too confusing to the jurors, the court will instruct the jury on what the law is. And as we've argued on these other motions, the court can't just start with the assumption that jurors aren't going to follow the law, that it's simply too concerning or too confusing for the jurors. The jurors will receive instructions. They are presumed to follow those instructions as a matter of law, and the court should assume that these jurors will do as they're instructed. And unless the court has any questions for me, that's all I have. Thank you, Your Honor.
Well, for the record, it really wasn't that confusing. We had the propensity aggravator in that
Thank
case.
you.
We put on
I
evidence that pushed back against that at that
I'm
point in the
confused as to
case.
why they are all
Um,
confused.
It's cleaner from
Yes.
the jury's perspective. It was cleaner from our perspective. I don't think we even argued about it. I think the state just went along with it. And I thought it went pretty well. And I definitely want to push back on the idea that, we have a tendency to have these tautologies in the law where we say, well, the jury is great and they'll figure it all out. And so long as we tell them what to do, then they've done what they were told. And there are studies that show that's just not accurate. I mean, there's the jury project. You can read what it's like for people to go through these things. And when we're talking about whether or not somebody's going to be put to death, I think it's important that we really think hard about how these people are going to make these decisions. If we're going to do a normal, just a penalty session, I definitely think it's something that's going to require some additional instructions. I know the Supreme Court just recently updated a lot of the ICGs, which is great, something that I've been advocating for. But there are additional things that I think are going to have to be told to a jury so that they can understand how that would function. And if you trifurcate it, it's going to make it simpler for them to understand, okay, you've now found this person guilty. Now you're going to be determining whether or not one of these statutory factors exists. This is what they are. This is how they're defined. You have to find this beyond a reasonable doubt. The state's going to do an opening statement and a closing. They'll put on evidence as to whether or not these things exist. This defense is going to come in, question those things, put on their case why those statutory aggravators don't exist. And you're going to make that determination. If you make that determination, then we get to a sentencing proceeding where the state's going to be able to put on any additional aggravators that it wants to put on, and the defense can then put on any other information that they have that's going to be a mitigation. It works, and it worked, regardless of whether or not the SAPD doesn't agree with me. I'd ask the court to consider it. Certainly, if the court decides not to do it, we'll have lots more conversations about how best to do that.
It's an intriguing idea. The concern, of course, is the desire to do this case once and not twice.
I
And
understand.
there's a protocol.
Sorry, guys, the feed just sort of crapped out there for a second, as it does sometimes. It's just spinny wheeling. Hold on.
Protocol that has
we
been
go.
approved
There we
by
go.
the appellate
Cool.
bodies versus the one that you're proposing now. And so that's always in a trial judges who tend to be fairly risk averse, difficult.
Yes, sir. Well, thank you.
Thank you, sir. All right, my dance sheet indicates that we have covered all the topics. Did I miss anything from either of your perspectives?
Not from the state, Your Honor. No motions, Your Honor, but I think Ms. Massoth has one thing.
One
Okay.
housekeeping.
Sure.
Judge, we submitted Professor Cover's PowerPoint and her data. We filed it this morning under seal. We had a conversation that you thought that that should probably not be under seal, definitely with the PowerPoint. We have no issues there. It was filed with one thumb drive. We discussed letting us look to see if there is victim information that needs to be redacted. So what I'd like your permission to do is file an amended Exhibit A, and if we'll get things redacted. The one that's filed and you were inclined not to seal, I just don't want it to get out there before we've had an opportunity to review that and redact names.
I'm assuming the state doesn't have an objection to that.
No objection, Your Honor. Thank you.
All right, and that's fine, counsel. Let me address, that brings up a good point in terms of just process for filing matters that need to be sealed in some way or the other, because as we know, the rules for filing require them to be physically filed if you're seeking to have them filed under seal, which causes some difficulty for most of you who are not in the Treasure Valley area. I think perhaps the best way to deal with this is if you're going to file something and there's some
Treasure
portion that needs
Valley.
to be under seal, if you would provide a redacted and an unredacted copy. So for example, I think the defense filed a recent request for discovery and had an exhibit attached that they felt should be sealed. I'm assuming that's why they requested to be sealed, was because of the exhibit. So you would file that one with, the exhibit just being a blank page saying redacted, and then provide the court and opposing counsel a courtesy copy of the unredacted, and then you can file the unredacted when you are here to get it filed under seal. And then we can let the public have the redacted version so that we, as much information as we can, make public we can.
We'll do it that way. Thank you.
That works for everybody.
Thank you, Your Honor.
Else for today.
Nothing else for today. There was a motion filed that got placed under seal that the court was going to schedule.
Is that about your jury voir dire procedure? Yeah, I think that's probably more appropriate to take up as we get closer to the pretrial than anything, because it really deals with essentially what is and isn't allowed in voir dire and in questioning. So I think it's just a little early in the game yet to get to that, from my perspective at least.
Your Honor, the only thought I have about that is perhaps talking about that may cause the court to think we should begin voir dire maybe a tiny bit earlier than is currently scheduled.
Well, we can, I think our pretrial is in May, correct?
I don't recall.
I think it's
would
in
trust the
May.
court on that.
And our voir dire is set to begin in August or late July. I can't remember. So I think we have some flexibility there, and perhaps we'll address it at another hearing before the pretrial. I just thought with the number of motions we had today, that it was probably something we could save for a later day.
Fair enough. Thank you.
All right. Anything else?
No, thank you, Your Honor.
So that I'm clear on the record with respect to why I sealed that. I don't think you submitted that intending it to be sealed originally. The reason I did is because it had in there specific questions that can and can't be asked of folks who are being questioned for about voir dire. And because of the extensive publicity here, I don't want to unnecessarily limit our available groups of veneermen.
We certainly have been there, done that. got
Because
that
they've
t-shirt.
read something about what questions to specifically expect to be asked. And so that was my reason for sealing that. Okay. All right. Well, thank you. Everybody have safe travels back. I will take the matters under advisement and issue written opinions forthwith. Thank you. Thank you.
And just like that, guys, they are done. Your job done, guys. Oh, goodness me. Okay, hold on. Okay, so I said stop sharing. Hold on. Can you guys still hear me? All right, yeah, cool. So that's it for the hearing, guys. And yeah, so I will, of course, as always, be on the lookout for those written orders in regards to all of these motions. I was hoping that he would have been a little bit more receptive to the last motion in regards to trifurcating the proceedings. He didn't really seem to be, but we shall see. Maybe we don't know this judge very well yet, and maybe he'll just surprise us all and actually consider what he heard about that. But yeah, so stay tuned. If you aren't already, make sure you subscribe and turn on the notifications so that you do know when those filings have come in and can be up to speed there. And I do have a playlist for this case as well as all the other cases that I'm covering and have covered in the past, just for if anyone is curious and wants to see all the videos grouped by the specific case. I do have those as well. Tomorrow night, we will be having the next installment of the Casey Anthony series. It's episode 10, and we will be hearing from Dr. Arpad Voss, who was infamous for testing air samples. It was a first, and to my knowledge, the last of its kind. He's quite the character, and it will be very interesting testimony for sure. So, but that's it for now. So thanks everyone for being here and for being a squirrel. And I will see y'all on the next one.